What arbitration appeal that is a request for listing on eight.
Listing senior court assen. Udyog. There is a senior court. You have to mention before the senior court for listing.
Last month it was listed here only. This was the case of this.
Go to court number 13.
13.
Yes.
Wait, please. I beg to mention item number 17, my lord. In that item, my lord, I have filed one IA, my lord, that has not been tagged, my lord. May I pray that, my lord, case may be listed with the IA, my lord, next week, my lord.
You have informed the other side.
My lord, I could not get him, my lord. The service is not complete, otherwise, my lord, only private. Only one respondent.
No mentioning without informing
Mal-
the other side.
The labor code decision was rendered against the government by directing to pay 33 crore. And the compliance report is to be from 8 months. But despite there is a direction from the Gauhati High Court to deal with the maintenance of particular matter, the matter was the order was passed in different direction. Also, the matter was listed already on urgency.
What is your prayer?
Tomorrow, urgency.
RFA.
Yes, CRP. Because 8 is the date of compliance, madam. It was already listed on Monday, but because of the non-availability of the bench, it could not be taken up.
PRP, you have to go before another court.
This has been so my lord, that is the problem.
No, you go through the roster. Court, Justice Kaushik Goswami's court.
Wait, please, Lordship. This matter relates to release of the amount deposited by the insurance company. Let the matter be listed on 8.
What is the matter? MAC appeal.
MSC appeal.
Okay.
Application filed for release of the amount.
Okay, thank you.
8, Lordship.
Item number 18 is already fixed on 21st of July. And now push another similar analogous. There is order.
So you want to say it is wrongly listed today? Item number? You have informed the other side. Heard Miss J. Sharma, learned counsel for the appellant. Also heard Mr. What is your name? A. Patra, learned counsel for the caveator respondent, who submits that by order dated 5/5/2025, it was directed that this matter be listed along with RFA number 42/2024 on 23rd of July. Hence, it is submitted that this appeal has been wrongly listed today. Stop the registry to list this matter on 23rd July 2026 along with RFA number 42 of 2024.
May I please, Your Lordship, beg to mention
Give this back.
beg
yeah.
to mention to MSC appeal for orders, my lord, and on the next week, any date, my lord.
Okay. 13th.
MFM veteran, I am for the victim, my lord, injured person, my lord. And case, my lord, and last listed on my lord 10/5/2019. Thereafter not listed, my lord.
In orders column,
In orders column,
next week.
My lord,
Next week.
11, my lord.
13th.
Another matter, MSc appeal matter, matter was last listed on my lord, 29/2022. my lord.
13th.
So this matter has been fixed for hearing, my lord, final hearing. Last, as per last order, my lord.
Then you have to request the registry,
My lord.
request registry.
Your Lordship, I beg for urgent listing of IA for MSA appeal of 17/2020.
When?
Sir, Your Lordship, the matter may be listed on 8th.
What is the urgency?
Your Lordship,
What is the urgency?
Your Lordship, the urgency is for withdrawal of the deposited amount by the claimant.
Okay. Okay, 8th.
8/5, Your Lordship.
Eighth. 31. Who is for the other side? You have informed. What is her prayer?
He wants an adjunct. Lordship, what she is saying is that already some analogous cases are fixed on 29/5. So this also may be listed on.
What is the case number? 108 on 29th. You have any objection?
But she did not inform. Copy to the.
Heard. Miss, what is her name? P. Gandhi, learned counsel for the cavator. Also Miss R. D. Majumdar, learned counsel for learned counsel for the appellant.
No, Lordship, she is the appellant. I am for the owner of the vehicle, Lordship.
Learned counsel for the respondent. No, but this is MAC appeal 31.
No, 112,
Uh,
item 31. Lordship.
Item 30. Okay. Learned counsel for respondent number 1. It is submitted. P. Gandhia for the appellant. It is submitted by learned counsel for the appellant that a matter arising out of same MSc case has been listed on 29th of May. That is MSc appeal number 108/2026. She submits that this appeal may also be listed along with the said appeal. Learned counsel for the respondent does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed along with MSc appeal number 108/2026 on 29th of May.
And the copy of the memo of appeal may be given.
The appellant shall furnish copy of memo of appeal along with annexures to the learned counsel for respondent number 1.
I'll oblige.
I pray for listing of an appeal matter, Lordship, in admission column. If a date could be given for the next week.
What was the last date?
The last date was 20th February.
What was ordered? On that day, what order was passed?
Never regarding that.
So it will be listed according to order passed on the last date.
Lordship.
Why are you mentioning?
Actually, I wanted it, the senior wanted it listed the next week.
But then you have to inform the court what was the order passed on the last occasion.
Lordship, I shall make a mention.
Okay.
Daily list, page hearing be item 8.
Yes.
Kindly put the order in 7
Atul. Computer section of Karma Mati to microphone take korbo aje. Yes.
My audible.
You have to be louder.
Your lordship will kindly produce order dated 7/4/26.
Yes.
My lord called for the medical person is supplemental. It is true. Was examined once in January. After that, repeated times matter has been listed. We have not know the stage, even after the order.
What is the case?
He has been arrested as rape.
Rape.
Lordship, I have received the report, Lordship, from
You have
the,
received.
I have received. It has clearly stated that he is diagnosed to have stones in both kidneys. With the treatment, his symptoms have decreased than before. It has been decreased.
Lordship, one thing. Lordship will kindly turn to page 33 of the petition. Side copy of the copy, handwritten copy, next page.
Yes. Not take us. Yes.
Very short letter. In reference to subject cited above, I want to.
Page number that.
Page number 33 and HS 7. on the
Yes.
bill.
Yes.
My lord has it.
Yes. What you want to show?
My friend has just submitted two stones in two kidneys. There were initially he was diagnosed with one stone. Now the matters have aggravated to such a level that he has two stones. That requires very specific treatment. The jail does not have the facility. That's what might be.
Everything is written in the report, Lordship.
Are they competent?
He has
to even look
given the
into that?
treatment, Lordship.
Does the jail have that? That's all the only question. The answer is yes, William. The answer is no, then I have.
Whether victim has been examined.
Twice, my lord. The lord will kindly.
Materials are there, Lordship. And in the medical report also, there has been implications is there, Lordship.
No, let me
Forceful is there
let me answer the question.
in the opinion,
The
Lordship.
lordship asked me the question, let me answer that.
Yes.
Placing that.
How many witnesses have been examined?
Lordship, I think it is 20, Lordship.
There are 20 listed witnesses. How many have been?
Is there, Lordship. It is attached to the petition, Lordship. I have written there, Lordship. So I need that. In the back side, I have written, Lordship. Moreover, TIP is also done, Lordship. She have identified the person.
No. Is there any independent witness?
Yes, Lordship. On independent witness is also there. She has also made TIP is there. She also identified the person.
Whether she has been examined.
Lordship, she has examined. She has stated also that, Lordship. It is there in the scan copy. Everything is there.
Lordship, if it's any condition, my lord, we need treatment, that's all. After
Everything is there.
No,
Lordship.
treatment you will be provided.
my humble respect, the email that the person is suffering from, that kind of specialized treatment is not available. That's the only issue.
Oh, you are getting treatment in medical college.
Take me there, they check it, and then again I'm back. I'm told that he's suffering from pain. Now it has been diagnosed, yes, he's told in two kidneys. Initially it was one kidney. It has aggravated to that level. It has aggravated to that level. That's a simple prayer.
That is not.
Respectfully, you do not have that certain or such kind of medical experience. Yeah, they have, I'm
In Lordship, the otherwise material, in regard to materials, everything is done against.
How many witnesses have been examined?
Lordship, 20 are there, I think, Lordship. The last page I have stated. Lordship, examination is in further examination of the victim, Lordship, but I have not seen it in the PW1, the victim person. I have not found it in the record. And it was stated that in the last order, further examination in chief on 4/4/2026. But in that regard, I have not any information on that, Lordship. Though it was called for updation, but I have not found that.
Let the victim be examined.
Lordship, victim has partly examined, Lordship.
partly examined. Last time.
No. Without examination of
Lordship.
victim, you cannot be released on that ground.
Partly examined.
Let the victim. This is for the first time you have approached this court.
Yes.
And where is your rejection order?
This is not third
It's
bill
not-
application.
it's not. I filed an affidavit. Affidavit.
Where is your rejection order?
Kindly take up the additional affidavit that was filed on 17/2/26. There are two orders.
Please.
17/2026, page 38.
I don't have that pages.
Also, Mr. K. Das, learned additional public prosecutor.
I don't have. No, it is last week. Okay, I know.
This application under section 483 of BNSS has been filed by the petitioner, namely Mustafizur Rahman, who has been detained behind the bars since 2/3/2025 in connection with Sessions case number 37/2025 corresponding to Mokolmo APS case number 48/2025 under section 64 within bracket 1 of BNS 2023. It appears that this is for the third time the petitioner has approached this court seeking bail. His main ground for seeking bail this time is that he is suffering from ailment, namely kidney stones, and for better treatment he is required to take treatment in a specialized hospital. Stop. Learned counsel for the petitioner submits that if the petitioner is granted bail, he is ready to cooperate in the trial. He also submits that the examination of victim has been done by the trial court. However, her further examination is fixed on another date. On the other hand, learned additional public prosecutor has opposed the grant of bail at this stage and has submitted that the victim girl has implicated the present petitioner with the offense with which he has been charged with. He further submits that the examination of victim girl is not yet complete. He also submits that there is one independent witness also who has identified the
VIP, Lordship.
identified the petitioner in the test identification period. He submits that the prayer for bail may only be considered after the independent witnesses, including the victim girl, are examined by the trial court. As releasing the petitioner on bail at this stage may give him an opportunity of influencing the victim girl and the independent witness. I have gone through the learned counsel for the learned additional public prosecutor has also produced the up-to-date health report of the petitioner given by the jail doctor. On stop, I have considered the submissions made by learned counsel for both sides. I have also perused the materials on record. On perusal of the health status report of the petitioner, it appears that he has been diagnosed with having kidney stones in both of his kidneys. However, his condition is under control and he has been provided treatment in the Nalbari Medical College and Hospital. Stop. It also appears from the status report of the trial pending against the present petitioner that the victim girl, the examination of victim girl has not been completed and her further examination in chief is fixed on 7/5/2025, 2026, that is tomorrow. The trial court shall make all endeavor to examine the victim girl and the independent witness who had identified the petitioner during test identification period as expeditiously as possible. After examination of the victim girl and the independent witness, the petitioner may approach the trial court and may seek bail before the said court. However, at this stage, this court is not inclined to grant bail, considering the status of the trial. Stop. The superintendent of Nalbari District Jail is directed to provide all necessary medical treatment which is required to be given to the petitioner. With above observation, this bail application is disposed of.
Never will be paid.
That I have indicated.
Item 9.
In this case, charge sheet submitted, Lordship. But it has been charge sheeted.
What is the offense?
Offense is under Lordship. 22C.
You approach the trial court. Oh. Who is your senior? Okay, for the timing.
Bill matter ordered, item 22 and 23.
In this case, Lordship, service report are supposed to be there, Lordship. but I have asked in the office lordship, we have not received. If possible, lordship, kindly fix on 11 or 12 lordship.
This case is lingering for so long.
2025. And
No, you ask the OC to serve the notice.
But I have not seen, this is my first time, lordship. I will,
No, you have telephonic
personally, I will do, lordship.
telephonic conversation with the OC
Lordship.
that
This
serve the
lord-
notice.
Lordship, that is why I take time, lordship. I will personally communicate, lordship, to communicate the
Heard
information.
Miss D. Ghosh, learned counsel for the applicant. Also heard Mr. K.K. Das, learned additional public prosecutor, who seeks some time to let this court know about the fate of the notice issued to respondent number 2 in the instant interlocutory application. He submits that he will personally contact the officer in charge of the jurisdictional police station to ensure due service of notice on the respondent number 2. Considering the submissions made by learned additional public prosecutor, the prayer is allowed. Let this matter be listed 18th May.
11.
Monday. No, let us give some time. Let it be on 1 week time, 18.
Much of-
32.
much obliged.
It will be on Monday, next Monday.
Item number 32.
Yes, who is?
But I am but the sole respondent in this case.
What is the case?
The matter relating to 125 proceeding maintenance case, my lord. The learned family court, my lord, directed to pay 4,000 per month. Here, the petitioner approached this honorable court and honorable court directed, stayed the impugn order directed to pay 3,000 per month, but he is not regularly paying. Therefore, your lordship vacate the interim order and they have filed an IA for notification, my lord. Last occasion also they took time and today is not appeared.
None has appeared for the petitioner on call. Mr. H.A. Ahmed, learned counsel for respondent, is present. Let this matter be listed 18th of May.
Admission, item 1.
May I please, Council? I may be allowed to withdraw this petition is because they are apart some important listing by the. That's why I may be allowed to withdraw and with a liberty to file a case. But all the petitions.
Heard Mr. T.R. Gogoi, learned counsel for the appellant, who prays for allowing the appellant to withdraw the instant appeal along with the interlocutory application, as some defects have crept in the memo of appeal and the interlocutory application, which is required to be rectified. He seeks liberty to file the appeal afresh after rectifying the defects. The prayer is allowed. This appeal is dismissed on withdrawal with the liberty sought for granted.
It may be directed to send back.
Send back what?
Original copy of the fairness.
No, it is, you want some documents back.
Some still document annex in the memo. That's a registry may be directed to sender B.
No, there is no such procedure of giving back the appeal. If you request, you can take back the original documents annex. I is also the same order.
Item two,
Dismissed on withdrawal.
May I please your lordship, my lord?
Yes,
May I proceed, my lord?
yes.
My lord, I am challenging the legality and validity of an order, my lord, injunction order, which was being made absolute. The injunction petition was filed.
Okay.
May I take a lordship to the 120 page number, my lord? That is the order, my lord.
What is your ground?
My ground is that, my lord, I am the landowner. I have filed a petition for ejectment, area of payment against the tenant, my lord, who was without any document, without any agreement, was in possession since 22 years. The property which I hold as an owner is a very valuable property, my lord.
What injunction you prayed for?
I did not pray for. I'm challenging that injunction order which has been prayed.
Which has been granted against you?
Yes, my lord. That is the order.
What is the injunction granted?
My lord, injunction was granted that, my lord, first of all, my lord, whether tenant can seek injunction from being eviction without performing his obligation. That obligation is to pay the rent to the landlord. Until and unless his rent is paid to the landlord.
Where is the impugn order?
My impugn order is on page 120, my lord, annex of 14, my lord, the last part. May I read it, my lord?
No. Okay, we are issuing notice. Heard Mr. K.D. Chaudhary, K.D. Chetri, learned counsel for the appellant. This appeal under Order 43 Rule 1R 1 within bracket R of the Code of Civil Procedure has been filed by the appellant impugning the order dated 10/3/2026 passed by the Court of London Civil Judge Junior Division number 3, Kamrup Metro in Miss J case number 171/2024 in connection with title suit number 121/2024, whereby the trial court granted temporary injunction against the present appellants.
No, my lord, temporary injunction was been made absolute. That is the absolute order I have challenged. 10/3/26. Which are lordship.
Whereby the temporary injunction granted earlier against the present appellant was made absolute. I peruse the grounds stated in the memo of appeal. Let the notice be issued to the respondents. Sole respondent?
Sole respondent, my lord.
Respondent. Let also the scan copy of the records of Miss J case number 171/2024 along with scan copy of the records of title suit number 121/2024 be called for. The appellant shall take steps for issuance of notice upon the sole respondent by speed post within 7 days from the date of this order, returnable on 3rd of June.
It all let me back. And further proceeding of the other proceedings are there, my lord, which will be stayed, my lord.
After receipt, after due service of notice.
Then, my lord, the 28/5, there is other proceedings are there, my lord. Violation is also there.
Got it. Dev.
22nd. No, my lord. With all respect, my lord, let returnable date stay there.
No. 1st of June.
28/5 is the other proceedings, my lord. He has filed title suit and he has filed miscases, various miscases. violations,
Nothing will happen.
Implementments, all are there, my lord.
Nothing
And
will
I have
happen.
annexed for your lordship perusal in the record, my lord.
Let the notice be served. 1st of June.
1st of June, my lord.
Yes.
With all respect. Till then, my lord, no any provision step that can be also.
Wait till 1st of June.
May it be taken up after some time, my lord.
Criminal case nothing. Okay.
Timing item 9.
আৰু criminal case আৰু আছে নেকি?
Sorry, my lord, there is no other court.
You appear before the trial court.
Simply that is. Oh, still sorry. Not for all.
What is this?
That your lordship, the 36, that not compiled in your lordship, observe that you have not taken exactly in the petition. So that's why you go. If they make it the plea that.
You can take this plea before the trial
Why
court.
not sincere that, let that records come, my lords. That will be better, my your lords will see whether the notice is there or not. If notice is there, even judge does not make any difference. To our information, charges not yet with my lord, put up before the court. Yesterday's information. You also see whether it has filed in time or not, my lord. Both things will be clear, my lord.
No, what is your ground? 36 has not.
That is especially your lordship mentioned, my. The order, page 34. A statutory figure also, my. Now both. Well, yes, other charges not put up, yesterday.
But it is stated that lordship charge sheet number is there and dated 15/12/2025.
How many days you are behind the bars?
2 days back.
When charge sheet was laid?
In my charge sheet dated lordship 15/12/2025.
No, regarding charge sheet, what is the submission?
Because if notice support 36 is violated. You can, I'm entitled. And about charge sheet, but yesterday information not yet put up because the court filed.
Okay. Heard Mr. H.R.A. Chaudhary, assisted by Mr. I.U. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that in this case, charge sheet has been laid and therefore petitioner may be directed to the trial court. On the other hand, learned senior counsel for the petitioner has submitted that the petitioner has taken plea of violation of the mandatory provisions contained in section 36 of BNSS, and therefore he prays for calling for the scanned copy of the trial court records. He also submits that regarding charge sheet, what is your submission?
Yesterday, till today, it has been put up before the minister.
That charge sheet has not yet been put up before the magistrate, though it has been stated that charge sheet is dated 15/12/2025. Stop. After considering the submissions of learned senior counsel for the petitioner, This court is inclined to peruse the scanned copy of the trial court records. Hence, let the scanned copy of the trial court records as well as the connected scanned copy of the connected case diary be called for from the trial court.
But
Let
this
the-
may be correct as a part of record because they have stated that it has not been submitted. That is my bad.
le- एक line দিব. On the other hand, learned additional public prosecutor after the petitioner's counsel. Additional public prosecutor has submitted that he has received a WT message from the officer in charge of Lakhipur police station, inter alia, informing that the charge sheet has been laid in this case bearing charge sheet number 159 dated 15/12/2025 against the present petitioner. Let this matter be 28th of May. 25th of May.
Item 4.
May I please? Lord, the present appeal has been filed under section 23 of Railway Act. Lord, may kindly call for RCP record.
Administer.
My lord, one submission, lord, my lord is issuing notice, my lord will see page 10 at the prayer, my lord, page 10.
Yes.
Prayer number 4, my lord will see. Issue a direction to the learned technical member of the RCT to undergo a judicial training at.
No, this kind of prayer you cannot make.
That is, my lord, will show a wrong precedent, my lord, notice is issued on this.
That is contemptuous.
My Lord, I'll rectify it. I'll file the amendment.
My lord, he can submit that these two prayers is not pressing, my lord, will not issue notice.
No, let him rectify the
I'll
memo of appeal.
I'll
Heard Mr. D. Rathi, learned counsel for the appellant, who prays for allowing the appellant to file a amended memo of appeal by rectifying the prayer number 4 as learned Central Government Counsel Mr. H. Gupta has pointed out that said prayer cast aspersions against the technical member of Railway Claims Tribunal and is not and would send wrong and would lay wrong precedent. Stop, the prayer is allowed. The appellant is allowed to rectify the memo of appeal and submit an amended memo of appeal before the next date. Let this matter be listed after a week on a date to be fixed by registry.
Item 5.
Matter we are challenging the judgment of award dated 25/11/24 passed by the learned administrative number 2 Kamru Metro. In this matter, your lordships
Miss, what is your name? P. Fukon. P. Fukon appearing on behalf of Mr. P. J. Burman, learned counsel for the appellant. This appeal under section 173 of MV Act 1988 has been preferred against judgment and award dated 25/11/2024. What happened in review? 25/11/2024 passed in MAC case number 366/2019 by the Motor Accident Claims Tribunal number 2 of 2 Kamrup Metro Gauhati, whereby the present appellant was directed to pay a compensation amount of rupees 15,34,742.50 paisa, along with an interest at the rate of 9% per annum to the respondent claimant. Stop. I have gone through the grounds stated in the memo of appeal and considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MAC case number 366/2019 be called for from the concerned tribunal registry to take steps for requisitioning the records. Let also notice be issued to the respondent. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of June.
Item 6.
Since 2023, we will develop further 26. We are ready to deposit 50% of labor.
Heard Mr. R. Sharma, learned counsel for the appellant. This appeal under section 173 of MV Act has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 2/2/2026 passed by Motor Accident Claims Tribunal Golpara in MAC case number 304/2022, whereby the appellant appellant company was directed to pay a compensation amount of rupees 24,07,000 to the respondent's claimant. Stop. I have gone through the grounds stated in the memo of appeal and considered the submissions made by learned counsel for the appellant. This appeal is admitted. Issue notice to respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of June. Let the records of MAC case number 304/2022 be also called for from the concerned tribunal.
Ready to deposit.
This interlocutory application has been filed by the applicant insurance company under Order 41 Rule 5 of the Code of Civil Procedure, praying for stay of execution of the judgment and award dated 2/2/2026 passed by the Motor Accident Claims Tribunal Golpara in MAC case number 304/2022. Stop. Learned counsel for the applicant has submitted that the aforesaid judgment has been impugned by the present applicant by filing the connected MAC appeal number 2110/2026 and the said appeal has been admitted. He further submits that the applicant insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award. Stop. Considering the submissions made by learned counsel for the applicant, the notice to the respondents is waived and this interlocutory application is allowed. The execution of the judgment and award dated 2/2/2026 passed by MSC, passed by Motor Accident Claims Tribunal Valpara in MSC case number 304/2022 shall remain stayed during the pendency of the connected MAC appeal number 2110/2026, subject to deposit of 50% of the awarded amount by the applicant before the registry of this court within 6 weeks from the date of this order. Disbursement. Okay. This interlocutory application is accordingly disposed of.
Item 7.
Appeal against the quantum of compensation. An amount of 11,50,000 was awarded against loss of earning capacity without even the certificate of disability or examination.
Mr. R. Goswami, learned counsel for the appellant. This appeal has been filed by the United Insurance Company Limited, United India Insurance Company Limited, impugning the judgment and award dated 29/1/2026 passed by the Motor Accident Claims Tribunal of Dalguri in MSC within bracket I case number 5/2021, whereby the appellant was directed to pay a compensation amount of rupees 18,25,152.08 paisa along with an interest. What is the rate of interest? Along with interest to the claimant respondent. Stop. Let the notice be issued to the respondents and let the records of MSC case number 5/2021 be called for from the concerned tribunal. Registry to take steps for requisitioning the records. Stop. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of June. List accordingly. Deposit 50%. This interlocutory application read the name of Mr. R. Goswami, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company under Order 41 Rule 5 of the Code of Civil Procedure 1908, praying for stay of execution of the judgment and award dated 29/1/2026 passed by the Motor Accident Claims Tribunal of Dalguri in MSC case within bracket I number 5/2021. whereby the present applicant insurance company was directed to pay a compensation amount of rupees 18,25,152 along with an interest at the rate of 6% per annum to the claimant's respondents. Stop. Learned counsel for the applicant has submitted that the aforesaid judgment and award has been impugned by the applicant in the connected MAC appeal number 213/2026, and the said appeal has already been admitted and notices have been issued to the respondent. He further submits that the applicant is ready to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment. Stop. Considering the submissions made by learned counsel for the applicant, the notice to the respondent/claimants is hereby waived, and this interlocutory application is allowed. The aforesaid judgment and award is hereby now the execution of the above mentioned judgment and award shall remain stayed during the pendency of the connected MAC appeal number 213/2026, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 4 weeks. 4 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Item 54 from supplementary list.
Please, Your Lordship. Your Lordship, what happened in this matter is that the claimant suffered some grievous injuries in an accident, and during the pendency of the claimant's case, the injured died. So now we are selecting the quantum. So I pray before Your Lordship, kindly grant us 2 weeks time so that we can settle the matter after. It's a field case for settlement.
Okay. Item number?
51.
Heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr. N.I. Khan, appearing for respondent number 1A, 1B, and 1C. It is submitted at bar that there is a possibility of amicable settlement between the parties, and therefore some time is prayed for the same. Considering the submissions made by the parties, the prayer is allowed. Let this matter be listed. June 5th of June. The registry shall reflect the name of Mr. N.I. Khan in the cause list as the engaged counsel for respondents. Respondent number 1, A, B, and C. List accordingly.
Item 55. Item number 55.
None has appeared for the petitioner on call. None has appeared for the appellant on call. Let this matter be listed in the next week on a date to be fixed by registry.
Orders. Item 10.
As per Lajima order dated 23/10/2025, respondent one is already appearing. As per law, order dated 23/10/25, notice duly served on respondent number 2.
The service is complete.
The LCR not yet.
Yeah. Heard Miss R.D. Majumdar, learned counsel for the appellant. None has appeared for respondent number 1.
Name is shown in the cause list.
Though name of the engaged counsel has been shown in the cause list. Lodgement order dated
23/10/25.
it appears on perusal of the office note dated 23/10/2025 that the notice upon respondent number 2 has been duly served by Dusty mode. Stop. The service of notice on the respondents is therefore complete. However, it appears that the records of the WC case number 79/2011 has not yet been received from the Office of the Commissioner for Workmen's Compensation, Bajali. Stop. Registry to issue a reminder for the same. List this matter again after receipt of the records after 2 weeks.
Item 11.
It's not just the injured person has an inferior for the date of his murder, it will be there. And we have also amended the cause title equity. This matter may be placed for settlement in local. It had already come in the last local, but because of this order.
Which Lok Adalat? This Lok Adalat. Who is appearing for the claimant?
He's appeared, I talked to him yesterday, he could not come.
Okay.
I had his consent.
Okay.
In fact, also, he said,
Mm.
he come in the last local.
Heard Mr. R. Goswami, learned counsel for the appellant. Though none has appeared for the claimant, learned counsel for the appellant has submitted that he has been informed by the engaged counsel for the claimant respondent that this matter may be amicably settled. Learned counsel for the appellant also submitted that this matter may be referred to Lok Adalat and the claimant respondent does not have any objection to the said offer. Considering the submissions made by learned counsel for the appellant, let this matter be listed before ensuing Lok Adalat on 9th of May 2026.
Item 12.
May please your lordship. My lord, I am the claimant, my lord. Last time on my lord 17/2/2025, my lord. Honorable court, my lord, was pleased to direct this matter placed before the Lok Adalat. But the claimant is ready to, my lord, settle this matter. Maybe taken up, my lord, on next Lok Adalat, 9th of May.
9th, you are ready to appear. Heard Mr. S. R. Sharma, learned counsel for the appellant. Also heard Mr. M.
Islam.
Islam, learned counsel for the claimant respondent. It is submitted at bar that there is a possibility of amicable settlement between the parties. and therefore it is requested that this matter may be listed before the ensuing Lok Adalat on 9th of May 2026. Stop. The prayer is allowed. Registry to list this matter before Lok Adalat on 9/5/2026.
Highly organized signature.
Item 13.
The logic in this case, service on R 4, 5, and 6 is yet not complete. But they are not necessary parties because the owner, driver, and payment, owner and driver is in respect to the offending vehicle have already appeared in our church.
Who are 4, 5, and 6?
Driver insure of the other vehicle, and our ground of appeal is on rear lordship. As such, they are not necessary parties.
But you have not taken steps.
31/5/2024.
You have taken steps on.
Awaited. However, as per the office note dated 29/4/2026, it shows that steps has not been found in the section. And since they're not necessary parties, I would pray for their names to be struck off.
We are not striking name, we are waiving notice. Heard Miss A. Biani, learned counsel for the appellant. Also heard Mr.
CM Mohanto.
C.M. Mahanta,
Respondent 1.
appearing for respondent number 1. On perusal of the office note dated 29/4/2026, it appears that the notices submitted by the present appellant for sending the same to respondent number 4, 5, and 6 were not traceable in the registry, though order dated 31/5/2024 reflects that the appellant has already taken steps for service of notice on the aforesaid respondent. Learned counsel for the appellant submits that the respondent number 4, 5, and 6 are not necessary for consideration of the instant appeal, and therefore their name may be struck off. Stop. Considering the submissions made by learned counsel for the appellant, the notice to respondent number 4, 5, and 6 is hereby waived. Records I say, as the remaining respondents have, as the notice, service of notice on remaining respondents has already been completed. This case may be listed for hearing after receipt of the records of the MSC case number. What is the 1063/2006 from the concerned tribunal. Stop. Registry to issue a reminder for requisitioning the records of the MSC case number 1063/2006 from the concerned tribunal. List this matter after 3 weeks on receipt of the aforesaid records.
Item 14.
Lordship, as per office note dated 2/5/26, AD has given a service report of R3 and 4 now proceeding. Lordship, respondent 1 to 4 are all from the same family. So I just.
Who is appearing for 1?
I am appearing.
You are appearing for others also. You may appear for it.
No. Your Lordship, the opposite party, respondent number 3 and 4 are opposite party in the claim. And I am the claimant. 1 and 2 are the claimants.
One is brother, one is husband. One is.
All are from same family member. No, all are from same family, Your Lordship. Your Lordship, the LCR has all been received. Now, if my learned friend agree, the issue is totally a legal issue.
One,
In the trial court also, this OP number 3 and 4 have not contested and the case proceeded.
Based on the fact that since it is in the same family, whether they will be first party or third party, because they are the legal heir of the owner of the vehicle. The respondent number 1 and 2 and 3 are all legal heirs of respondent number 4. He is the owner of the vehicle.
So, Your Lord,
have you taken steps by speed post? To take steps first. Once let them take steps. Because speed post we can services.
Your Lordship, the problem is this is an appeal of 2019.
Yes.
And last time it was listed perhaps on 10/5/23 and it is 26.
We'll give
So-
fixed dates. Let them take steps. Heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. D. Mandol, appearing for respondent number 1 only.
2 services complete.
Earlier he submitted the case appearing for 1 and 3.
Your Lordship, even I don't appear for 2. Nothing has been awarded in favor of 2. Only
But
mother
you
has
are
been-
not appearing.
No, I will not appear.
Okay.
So service is complete.
Who submits that? क्या लिखा? For the respondent number 1, he submits that he is not appearing for respondent number 2, though the service of notice upon the said respondent is complete. It appears that the notice, the service report in respect of notice issued to respondent number 3 and 4 has not yet been received. The appellant is directed to take fresh steps for issuance of notice upon respondent number 3 and 4 by speed post within 7 days from the date of this order, returnable on 3rd of June.
But it will be a bit later than that.
12th of June.
Hello, guys.
Oblige, Your Lordship.
Item 15.
Okay. I had a sum of a substitution of the legal as a respondent number 2.
Condonation, you have any? How much delay? You have any objection? Heard Miss A. Biani, learned counsel for the applicant. This is in IA number 99. Also heard Miss, what is her name?
P. Talukdar on behalf of KR Patil.
C. Talukdar,
P.
P. Talukdar, appearing on behalf of Mr.
KR Patgiri.
A.R. Patgiri, learned K.R. Patgiri, learned counsel for respondent number 1. This interlocutory application has been filed by the applicant insurance company, praying for condoning the delay of how many days? 528 days in filing the application for setting aside abatement and substitution of the legal heirs of respondent number 2, who has respondent number 2, namely late Abdus Salam, who has who is respondent number 2? Abdus Salam,
Salam. Abdul Salam.
Abdus Salam, who expired on when he died.
11/4/2018.
11/4/2018.
18.
Learned counsel for the applicant has submitted that the applicant has stated the grounds for delay in paragraph number
5 and 6.
3, 4, 5, and 6 of the instant application. Learned counsel for the respondent has not opposed the prayer for condonation of delay considering the grounds mentioned in the instant interlocutory application. Stop. After going through the grounds stated in the instant interlocutory application, this court is of the considered opinion that same may be regarded as sufficient grounds which prevented the applicant in preferring the setting aside of abatement application and substitution application within the prescribed period of limitation. Accordingly, the delay of 528 days in preferring the application for setting aside abatement as well as substitution of legal heirs of respondent number 2 is hereby condoned, and this interlocutory application is accordingly disposed of. Setting aside abatement. Heard same Ms. Biani and Talukdar. This application under Order 22 Rule 4 of the Code of Civil Procedure has been preferred by the applicant insurance company for setting aside abatement of the appeal against respondent number 2 on his death. Stop. Though there was delay in filing of the instant application, however, by order dated 6/5/2026, passed in IC number 99/2020, the said delay has been condoned. The learned counsel for the you are for respondent number 1 claimant. Learned counsel for the respondent number 1 claimant has not objected to the prayer. Stop. Considering the grounds stated in the instant application, the prayer for setting aside abatement is allowed, and the abatement of abatement of the connected appeal number 51/2016 on death of respondent number 2 is hereby set aside. This interlocutory application is accordingly disposed of. Next 100 parties names in. This interlocutory application has been filed by the applicant insurance company under Order 22 Rule 3 of the Code of Civil Procedure for substitution of the legal heirs of deceased respondent number 2, late Abdul Salam. Learned counsel for the claimant respondent has not opposed the prayer. Considering the grounds stated in the instant interlocutory application, the prayer is allowed, and the legal heirs of deceased respondent number 2, Abdul Salam, are allowed to be substituted in his place. Accordingly, Ms. Aisha Khatun Lokman Ali, Shahrukh Ali, Saiful Islam, and Nouriz Ahmed are allowed to be substituted as respondent number 2 within bracket A, 2 within bracket B, 2C, 2D, and 2E respectively in place of the deceased respondent number 2, Muhammad Abdul Salam. Stop. The appellant shall submit the corrected memo of appeal in the connected MFA number 51/2016 within a period of 1 week from the date of this order. This interlocutory application is accordingly disposed of. Amended cost rate. क्या लिखा? Amended? No, amended cost title. Corrected memo of appeal की जगह amended cost title in the connected appeal.
Item 16.
Service of the respondent on number 1 is completed for order date matter 18/3/24. We are also received.
Heard Mr. R.C. Paul, learned counsel for the appellant. Also heard Mr. M. Islam, learned counsel for respondent number 1.
One.
It appears from record that service of notice on all the respondents is complete, and this make appeal is ready for hearing.
Yes, sir, also received.
The records of the concerned MSC case has also been received. Accordingly, list this matter for hearing on 23rd of July.
Ali oblige your lordship.
Item 17.
Wait, please. Yes, my lord, I filed one IA, my lord, that has not been tagged, my lord.
Administrator B.
P. Sundi. P. Sundi, my name has not been shown, my lord, that might be reflected. my lord.
P. Sundi. Learned counsel for the applicant. None has appeared for the respondent. Learned counsel for the appellant has submitted that the appellant has filed an interlocutory application
On 1/9.
on 1/9/2001
Sorry, 9/5, my lord.
on 9/5.
My lord, 1/5, my lord. Sorry.
On 1/5/2026. However, same has not yet been tagged with the record. He prays for listing the interlocutory application along with this appeal and list this appeal on some other day. The prayer is allowed. Registry is directed to tag the interlocutory application filed by the present appellant along with this appeal and list this matter
Can it
again
be on next week, my lord?
on 18th of May.
Item 19.
One and 4 they have all elected, but they are not. They have filed local number. If the process is stay may be considered as.
Service is complete.
1, 4 have filed local number. The office note, process is 24.
Heard Mr. R. Goswami, learned counsel for the appellant. On perusal of the office note dated 24/4/2026, it appears that the engaged counsel for respondent number 1 to 4 have submitted their wakalatnama in this case. and their names are also reflected in the cause list. However, none has appeared for them. Whether records have come? Records. It also appears that they reflect her name. What is your name?
Sir, I'm here on behalf of Bibara, responding 1 and 2.
What is your name?
P. Yepto.
P. Lepto.
Yepto.
Reflect her name P. Lepto, appearing for respondent number
1 and 2.
1 and 2 appears. Stop. The records of the concern MEC case is has also been received, and therefore this appeal is ready for hearing. Let this matter be listed for hearing on 30 July. August of Dibapare. 4th of stay we will be granting. You deposit 50%. For 4th of August.
Hearing is delayed then.
Heard Mr. R. Goswami, learned counsel for the applicant. Also heard Ms. C. Lepto, P. Lepto, learned counsel, appearing for respondent number 1 and 2. This interlocutory application has been filed by the applicant insurance company under Order 41 Rule 5 of this Code of Civil Procedure 1908, praying for stay of execution of the judgment and award dated 8/7/2024, passed by the Motor Accident Claims Tribunal, Dibrugarh, in MEC case numbers 27/2019, whereby the applicant insurance company was directed to pay a compensation amount of respondent rupees 45,66,000, along with an interest at the rate of 7.5% per annum to the respondent number 1 and 2 claimant. Learned counsel for the appellant has submitted that. You have anything to submit?
My sentence. Currently in court number 1.
We are allowing. Learned counsel for the applicant has submitted that the applicant insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award during the pendency of connected MAC appeal number 122/2024. Stop. Considering the Mr. Burwa, we are granting stay subject to deposit of 50%. Considering the submissions made by learned counsel for the respondent claimant does not have no objection.
Respondent 1 and 2.
Respondent 1 and 2 does not object to the said prayer. Hence, same is allowed. The execution of the impugned judgment and award dated 8/7/2024, passed in MSC case number 27/19, shall remain stayed, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order.
I submit, my lord. On such deposit, my lord, if your lordship allow to release.
Such deposit, if the said deposit is made in pursuant to this order by the insurance company, registry shall release the same to the claimant respondent number 1 and 2 after proper verification. This interlocutory application is accordingly disposed of.
Item 20.
This is your lordship. Inadvertently, lordship, we have taken such steps only yesterday, lordship. We had
Heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. A. Bhattacharya, learned respondent,
Number 1.
learned counsel for respondent number 1. How many respondents are there?
2.
Learned counsel for the appellant submits that the appellant has taken steps for issuance of notice upon respondent number 2 only yesterday, and therefore she prays that the service report may be awaited. Let this matter be after listed on 4th of June.
I.
Anything?
Well, there is a IA pending. I insisted that that may be taken up.
lordship, let the owner appear because we are.
4th of June we'll decide.
Public.
Item 21.
Respond number 1 and 2, service is not complete, but what we have already a Bakizai notice has been issued. It has been admitted, stay pending because of the.
You deposit 50%. Let them deposit 50%. We grant stay. You take.
For driver and owner loss. Yes, lordship.
Is effect for a small tree driver.
The claimant has not appeared.
Even as not.
How many claimants are there? 2 claimants. Now what is to be done?
50% they can file an application for, because here I am challenging the liability itself. There is no policy.
Heard Mr. R. Goswami, learned counsel in the appeal. Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. M. Khan, appearing for respondent number 3 and 4. The notice sent to respondent number 2 has returned without service, whereas the service report in respect of notice sent to respondent number 1 is awaited. Stop. You take fresh steps
That's the second.
by speed post as well as by Dasti. Learned counsel for the appellant prays for allowing the appellant to take fresh steps. The prayer is allowed. The appellant shall take fresh steps for issuance of notice upon respondent number 1 and 2 by speed post within 7 days from the date of this order, returnable on 4th of June. The appellant is also allowed to take steps additionally by Dasti mode on respondent number 1 and 2. Stop. In the event the appellant is able to serve the notice on respondent number 1 and 2 by Dasti mode, it shall file an affidavit of compliance before this court on the next date fixed. List accordingly. Issue reminder for the records of MSC case number 13/2022 from the concerned tribunal. Registry to issue the reminder. IA. Heard Mr. R. Goswami, learned counsel for the applicant. Also heard Mr. M. Khan, learned counsel for respondent number 3 and 4. It appears that the notice issued to that the service report in respect of notice issued to respondent number 2, 1 has not arrived, whereas whereas the notice issued to respondent number 2 has returned without service. Therefore, in the connected MAC appeal, the applicant has been directed to issue fresh notice. He will also issue notice in the applicant shall also take steps for issuance of notice in the instant interlocutory application in the same way as has been directed in the appeal. Stop. However, learned counsel for the applicant has submitted that the claimant respondent have already filed an execution case before the Bakijai officer and any notice has been issued. What?
Case record put up today, or under this case has not been declared, what will you put to execution in the 6 months? Thank you. If not declared in 7 days.
Next date is? Hence, he submits that in the interim, till the appearance of the respondent claimant in the connected appeal, the stay as prayed for may be granted. Here, learned counsel for the applicant further submits that the insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment and award. Stop. Considering the submissions made by learned counsel for the applicant, the prayer is allowed. The till no, prayer is allowed. Stop. Let this matter be listed again on 4th of June. In the meanwhile, the execution of the impugned judgment and award shall remain stayed, subject to deposit of the 50% of the awarded amount by the applicant insurance company before the registry of this court. It has to be of a shorter duration. For you deposit within 3 weeks, subject to deposit of the awarded amount within 3 weeks of the date of this order, list accordingly on 4th of June.
Item 24 and 25. Item 24 and 25.
None has appeared for the petitioner on call. Let this matter be listed again on 18th of May.
Item 26 and 27.
None has appeared for the petitioner on call.
I am appearing for respondent insurance company,
27.
26, 27, madam. Chunki.
None has appeared for petitioner on call. Stop. Miss L. Sharma appears for the
Insurance one.
respondent insurance company. Let this matter be listed again on 18th of May.
Item 28.
So I've taken steps on 8/4/26, so that we can be elected. Reminder for election mechanism.
What has happened regarding notice to the respondents?
8/4/26, I think. So service may can be erected and this LCR may can be, reminder may can be spread.
But office note shows that you have not taken steps.
But there is a word notice, leave it, there is a matter of record. Notice there is sent to us. Step taken on 8/4/26, that has been sent to him. Reminder for us.
Okay. Heard Mr. A.R. Agarwal, learned counsel for the appellants. On perusal of office note dated 4/5/2026, it appears that though notice have been issued to the respondent number 1 and 2, the service report is awaited. The registry shall place the postal track consignment report of notice issued to respondent number 1 and 2 by speed post on the next date fixed. Let also a reminder be issued for the records of MAC case number 454/2022 from the Motor Accident Claims Tribunal number 3, Kamrup Metro. Registry to take steps for issuance of reminder for records as well as for placing postal track consignment as before this court as directed. Let this matter be listed 2nd of June.
Item 29.
As per office, as per models. Completely steps are complete. The board has been reached.
When have you taken steps? Okay.
Taken the steps, it shows it's not reached.
Okay. Okay, heard Mr. What is your name?
JS
J.A. Singh, the learned counsel for the appellant. Also heard Miss M. Chaudhary, learned counsel for respondent number 1. Office note dated 30/4/2026 shows that the notice issued to respondent number 2 to 4 has not yet been served on the said respondents. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2, 3, and 4 by speed post before this court on the next date fixed. Let this matter be listed on 19th of May.
Item 30.
As per office note dated 4/5/26, notices are sent to respondent 2 and 3 by speed post as usual, so we have to await them.
Lordship, just 2 days back, Lordship is sure.
Okay. Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. I. Hawk, learned counsel for respondent number 1. Office note dated 4/5/2026 shows that though the steps are taken for issuance of notice on respondent number 2 and 3, however, service report is awaited. The registry is directed to place the postal track consignment reports of the notice issued to respondent number 2 and 3 by speed post before this court on the next date fixed. Registry shall also issue reminder for the records of the MAC case number 28/2022 from the concerned tribunal. List this matter on 3rd of June.
Lordship, I have filed an IA, but this I already numbered, but it's not a text, the record, Lordship.
Learned counsel for respondent number 1 has submitted that the respondent number 1 has filed an interlocutory application which is not placed along with this appeal. Registry is directed to list the interlocutory application filed by the respondent number 1 before this court along with this appeal on the next date fixed.
Highly of this.
Item 33.
Filing the subsequent petition, there is a delay of 59 days.
Who died?
After passing the suspect.
कॉपी दिया नहीं तुम्हारे ना दिया नहीं हाँ देख लो my lord they have not furnished the copy my lord
Furnish the copy.
Get me please.
Okay. Heard. Mr. What is your name? What is your name? And Mr. A.U. Ahmed, learned counsel for the applicant. Also, Ms. L. Sharma, learned counsel for the respondent insurance company, who submits that she has not received the copy of the interlocutory application till date. The applicant is directed to furnish a copy of interlocutory application along with annexures to the learned counsel for the respondent insurance company. The registry is directed to reflect the name of Mr. A.U. Ahmed in the cost list as engaged counsel for the applicant henceforth. Let this matter be listed 25th May.
Item 44.
Also, because some steps are not taken.
What mistake? No, but when you say that due to some mistake, you must also tell the court what mistakes. Heard, Mr. What is your name? A.L.E. learned counsel for the applicant, who prays that due to some communication gap, the applicant could not take steps as was for issuance of notice upon the opposite parties as was directed by this court. He prays for some more time for taking steps. The prayer is allowed. The applicant is directed to take steps for issuance of notice upon the opposite parties by usual mode as well as by speed post within 7 days from the date of this order, returnable on 8th of June.
Item 35.
Lordship, here also Lordship, as per official dated 4/5/26, notices to respondent 1 to 5 are sent by speed post and usual post.
Heard Ms. Adi Majumdar, learned counsel for the applicant. The office note dated 4/5/2026 shows that the notice issued to respondents by speed Have you taken, yes, by speed post as well as by usual mode have not yet returned. The registry is directed to place the postal track consignment report of the notice issued to respondent number 1 to 5 by speed post before this court on the next date fix. List this matter again on 19th of May.
Item 36.
PCR.
Also issue reminder for the records of MAC case number some
One.
MAC case number 111/2022 from the Motor Accident Claims Tribunal, Sonitpur. Six, heard Miss L. Sharma, learned counsel for the applicant, who prays for some more time for taking steps for issuance of notice upon the opposite parties. The prayer is allowed. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of June.
Item 47.
Lordship, service report may be awaited in respect to respondent number 1 and 3. And we may be allowed to take fresh steps upon respondent number 2.
Ms. M. Sakya, learned counsel for the applicant. On perusal of office note dated 2/5/2025, it appears that the notice issued to respondent number 2 has returned with a postal endorsement within inverted comma unserved notice with a illegible postal endorsement. Stop. Learned counsel for the applicant has prayed for allowing the applicant to take fresh steps for issuance of notice upon respondent number 2. The prayer is allowed. The applicant shall take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of June. The registry is directed to place on record the postal track consignment report of the notice issued to respondent number 1 and 3 by speed post, before this court on the next date fix. List this matter again on 8th of June.
Item 38.
Lordship, respondents. It may be awaited in respect to respondent number 1 and 5. And we may be allowed to take steps upon respondent number 4.
Ms. M. Sakya, learned counsel for the applicant. On perusal of the office note dated 2/5/2026, it appears that notice issued to respondent number 4 has returned with an illegible postal endorsement. Stop. The appellant shall take fresh steps for issuance of notice upon respondent number 4 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June. The registry shall. What happened to 2 and 3? The registry shall place the postal track consignment report of notices issued to respondent number 1 and 5 before this court on the next date fixed. Let this matter be listed on 10th of June. 8th of June. 8th of June. Deo.
Timing item item 3.
Before my learned friend starts, I've got one objection to the maintainability of the appeal. My lord, this impugn order is an order passed under Order 21 Rule 97 on a petition under Order 21 Rule 97. My lord, in terms of Order 21 Rule 103, it becomes a decree and appeal lies under Section 96 of the Civil Procedure Code. The present appeal has been filed under 21-104. So the appeal has been first corrected now.
What is 104, 21-104?
104 says, my lord, if your lordship takes up 104.
But I'm being 103. That's a typographical error.
103 also, my lord, it will be Section 96. My lord, what I'm saying is, if your lordship goes to 103 first, my lord, orders to be treated as decrees. What we has got, my lord?
Yes.
Order 21, Rule 103.
Just a minute. Yes, 103.
Yes. Where any application has been adjudicated upon under Rule 98 or Rule 100, the order made thereon shall have the same force and be subject to same conditions as to an appeal or otherwise as if it were a decree. So it only says that the order passed on a petition under Order 21 Rule 97, making an adjudication under Rule 98 and 100 will be a decree. It will be treated as a decree. Now, if it is a decree, then the appeal lies under Section 96 of the
What is 104?
104 says, my lord, order under Rule 101 or Rule 103 to be subject to the result of pending suit is something slightly different one.
Lord, I stand corrected. 103, it's a typographical error. Since 103 says it'll be treated as a decree, my learned senior friend is absolutely correct. A first appeal would lie. So
Yes.
that is how we are here. We filed the first appeal. Only thing is we may not have cited Section 96 in express. That's
You cite it.
I'll cite it. Your lordship will allow me to correct it by, and I just need to insert 96. That's all. Otherwise, it is an appeal problem.
Correct, my possibly nowadays it is not permissible for correcting.
Otherwise, whether nomenclature of the appeal would change, it will still remain regular first step.
Remain same, but
They can correct the cause title.
But they are invoking Order 21 Rule 104. That's what I'm saying.
No, that they have to rectify.
Yes, that's what I'm saying.
You rectify it. We'll take it after you rectify it.
The problem is, perhaps that is why the objection is raised. The execution, the bailiff has visited several times. It is fixed for on 8th for report.
If you're
This is too technical, if I may submit with utmost respect. This is too technical, my lord. Otherwise, it continues to remain as an RFA, my lord. It conforms to Appendix G of the Civil Procedure Code, my lord. Only thing is 4 should have been table 3. That's all.
My lord, here I make one suggestion. My learned friend's client is showing urgency about some writ of delivery position. My lord, writ of delivery of position was issued in the year 2020. Thereafter, my lord, they have filed and not in respect of them. Not in respect of
No,
them.
it is a simple thing
My lord.
of correcting the
Yes.
cause title. Cause title only. Other things,
Yes.
you correct it.
Yes.
We'll take it tomorrow, day after tomorrow, whenever you correct it.
Can I correct it by hand?
No.
Becomes 3. That's one.
Then they will again raise objection that there is a circular.
The problem is page 420.
It will be under Section 9. My learned friend is aware. First appeal is under Section 96. Second appeal under 100. There is no.
Yes, when it has been pointed out, let it be corrected today. How much time will you take for correction? You have to. We'll take it tomorrow. Take up tomorrow.
Well, let it be different. Tomorrow, my lord, I have too many.
Date fixed for report, that's the problem.
Then let it be tomorrow, my lord, I'll have to somehow adjust.
Otherwise, if your lordship, your lordship can order me to correct it, in the meanwhile, take it up for consideration at least. This hyper.
My lord, there is absolutely no urgency. I am showing my lord why. Lordship will kindly turn to page 284. This is the ground document on the basis of which they are showing this urgency. Earlier also they came once, they have shown urgency. I undertook that we will not take any step. In fact, my lord, this is a writ of delivery position order of 2020, not in respect of them. This is number one.
Okay,
Well,
rectified. Heard Mr. B.D. Decker, learned counsel for the,
New order.
or the appellant. Also heard Mr. D. Majumdar, learned senior counsel assisted by Mr. S. Vishwas, learned counsel for respondent. How many respondents? All respondents. All respondents. This appeal, this regular first appeal has been registered on filing a memo of appeal under order 21 rule 104 of the Code of Civil Procedure 1908, impugning the order dated 23/4/2026 passed by the Court of Learned Civil Justice Senior Division number 2 in Ms. J case number 19/2026 arising out of title execution case number 4/2012. Learned senior counsel for the respondents has raised a preliminary objection as regards maintainability of this appeal under order 21 rule 104. He submits that any order passed in after adjudication of an application under order 21 rule 97 has to be treated as a decree under rule 103 of order 21, and therefore he submits that appeal under section 96 of the CPC is maintainable. Learned counsel for the appellant admits the typographical mistake in the cause title of the memo of appeal and seeks some time for rectifying the cause title. The prayer is allowed. Let this matter be listed again.
My lord, may I pray that let it be listed on 20th, maybe the entire matter may be disposed of on the 20th.
Let it come first for admission tomorrow on 7th of May 2026. The appellant is allowed to rectify the error which has crept in the memo of appeal. He shall submit the corrected memo of appeal.
May I pray, my lord? Let it be on 20th. I've got difficulties, my lord, tomorrow also. Let it be on 20th, my lord. My land friend is expressing apprehension that he may be evicted. My lord, in this period, well, nothing will happen. So many steps are necessary to be taken before the exact eviction, if any, takes place. It's a suit of 1987, my lord. There were at least 10 to 15 persons who were ultimately, my lord, there was a preliminary decree. So many things have happened in the meantime. And he has initially filed one order 21 rule 97, then withdrew, taking a different type of stand. Then he filed a suit, taking a different type of stand. Then suit was rejected under order 7 rule 11. Appeal has been preferred, appeal is pending. Then
You are seeking any interim?
Desperate. That's the difficult.
My lord, I am assuring, my lord, in these 7 days, nothing will happen. Nothing will happen.
Then your lordship will record that undertaking.
It's not an undertaking, but I'm saying, my lord, nothing will happen. Execution is pending. And my lord, last time also when they came in a revision against the initial order where the land court below has said that I'll hear the maintainability first. Nothing has happened in the meantime.
Well, in that case, your lordship, whether can, since it's too technical, your lordship can consider it today if my learned senior friend has a.
That's why I'm
difficulty
saying
tomorrow.
if it comes on 20th.
No,
then
let
better
it
can-
come tomorrow.
I know.
We'll decide tomorrow.
Tomorrow, all right, man, because day after tomorrow is the day. Otherwise, man, tomorrow I've got one division bench matter, single bench also, my lord. 2 o'clock there is one another division bench.
We'll accommodate you.
My lord.
Tomorrow, during the course of the day, we'll take up accommodating both sides.
Lordship may record my submission that till this 20th.
You will not
My-
go for execution.
Yes, because on that day, my lordship will take it up for final disposal.
Though this court was inclined to list this matter tomorrow, that is on 7th of May 2027, 2026, however, learned senior counsel for the respondents showed some difficulty on his part and prayed for listing this matter on 2020,
Right.
25 to 2026.
Right.
He also submits that the respondent shall not pursue the execution of the decree against what is execution of
Just one thing, they probably have, we do not know, that is why I wanted to draw your lordship's attention to page 420, my lord. 420, the LR staff, along with the settlement officer, have been reminded to complete it and submit a report. So perhaps without their pursuing also, I can be evicted, my lord. Page 420 is
We'll have
very
to
clear.
take steps for that, my lord. We will not.
The steps were directed to be taken on 23/4/26.
My lord, lordship will kindly see decree holders to take steps. We
Yes.
have to take steps. So if we do not take steps, my lord, nothing will happen.
So your lord, they have not, so I take it that they have not taken steps till now. Let that also be recorded.
no, we till 20 will stay the
Yes, my
execution
lord, your lordship.
till 20.
My lord, stay is not necessary. I am giving an undertaking that we will not take any steps.
Things will remain same.
Yes, my lord.
क्या लिखा
Till 20th.
Till-
That will help.
till 2025
5.
2026.
Okay.
And hence the orders. And the-
Considering the submissions made by learned counsel for the parties, let this matter be listed on 25 2026. Till then, the execution of the which decree?
The title execution.
I don't
4
know,
of
stay,
2012.
when I give this assurance, my lord,
Right.
another stay is not necessary. I am
No.
giving an assurance that I will not take any steps.
No, on the basis of your assurance, I am giving stay.
My lord, my assurance is enough that I will not take any steps, so they
That,
will not
that,
be effective.
that will not make any difference.
Because
Considering
I have
the
to take steps, my lord. Order says I have to take steps for his eviction.
Now, considering the submissions made by learned counsel, senior counsel, the title execution,
Difficulty is if your lordship passes that kind of order, if 20th, if the matter cannot be taken up, my lord, there will be automatic extension. This will create any difficulty. I am giving this, my lord, assurance and my lord,
no,
concession from my side.
it is limited. Till title execution number 4/2000 shall remain stayed till next date. 20.
Item 39.
No, we are appearing for response number 1 and 2.
In,
But same case, not for all the respondents.
okay, respondent number 1 and 2.
Thank you so much. Lordship, service report may be awaited with respect to respondent number 1 and 3. And we may be allowed to take fresh steps on respondent number 2. As for office note dated 5/26.
यूं तो मत ही बुलाएंगे Nagor metal, both parties. Yes, Ms. Kyaki Cox.
Service may be awaited in respect of 1 and 3. And
Ms. M. Saikia, learned counsel for respondent and learned counsel for the applicant. On perusal of the office note dated office note dated 2/5/2026, it appears that the notice issued to respondent number 2 has returned without service with illegible postal remarks, whereas notice issued to respondent number 1 and 3 have not yet been returned. The applicant shall take fresh steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 8th of June. Whereas the registry of this court is directed to place the postal track consignment report in respect of notice issued to respondent number 1 and 3 by speed post before this court on the next day. Let this matter be listed on 8th of June. Yes, Mr. Deka, your appeal is defective. You cannot get interim relief. That was an error on my part. This court cannot give any relief. It would be on the basis. No, then I will only reflect their concession. That can be done. That they will not go.
Only problem is,
But
I think it's correct.
maybe, but appeal is not admitted because of some defect. Whether any relief, interim relief can be granted in such a case. They are giving concession. That concession.
Then I press, let it come out tomorrow. Because your lordship 28/4, several reminders have got, 28/4, they've got nothing to do with it. The LR staff has been directed to complete it, they think, despite it being.
No, I am not on that issue.
So that's why I'm pressing for tomorrow, either tomorrow or your lordship will protect me by a staying. That's my humble submission.
Tomorrow we will give again, extend it to 20.
Lord, I may correct myself, my lord. I am instructed to appear on behalf of respondent number 1 to 6, and for rest of the respondents, my lord, someone else will be appearing. So just now I contacted the client. We filed the caveat on behalf of respondent number 1 and 2. Now I have the instruction to appear up to 6, my lord.
Okay, 1 to 6, 1 to 6. And no.
As if the appeal is not maintainable, I just need to make a correct, ministerial correction.
No, it is not maintainable in its present form.
A misquote, a misquote.
For whatsoever reason.
But then your lordship.
We'll fix it tomorrow. Tomorrow, after correction, we will extend it to. We'll see what will happen tomorrow. We are fixing it tomorrow. Mr. D. Majumdar may appear or you may appear.
Yes.
Let this interim relief portion to Katedibu. Let this matter be listed again on 7th of May. 7th of May. Tomorrow.
Much obliged.
Item 40.
Item
Lordship will file this IA for withdrawal of the statutory deposits. Circuit has already been disposed of.
heard Ms. M. Sakia, learned counsel for the applicant insurance company. This interlocutory application has been filed by the applicant insurance company for praying for praying for refund of the statutory deposit of rupees 25,000 filed by the applicant insurance company at the time of filing of the MAC appeal number 338/2018. Learned counsel for the applicant has submitted that the aforesaid appeal has been disposed of on which when on 22/2026 by this court 20 February 2026 by this court. However, no order as regards refund of the statutory deposit was made in the judgment passed by this court. Stop. After going through the judgment passed on 20/2/2026 in MAC appeal number 338/2018, it appears that no order for refund of the statutory deposit was made therein. Hence, this interlocutory application is allowed. The registry is directed to refund the statutory deposit of rupees 25,000, which was made by the present applicant insurance company at the time of filing of the MAC appeal number 338/2018 after proper verification. This interlocutory application is accordingly disposed of.
Nowadays, Reliance General Insurance Company Limited name has been changed to since General Insurance Company Limited.
Learned counsel for the applicant has further submitted that though at the time of filing the appeal, the MAC appeal number 338/2018, name of the appellant insurance company was Reliance General Insurance Company. However, the name has now been changed to
General Insurance Company.
IndusInd General Insurance Company Limited, and therefore the appellant with its new name may be allowed to withdraw the statutory deposit. The prayer is allowed. This interlocutory application is accordingly disposed of.
Item 41.
Matter has been listed for the first time. There's a delay of
Heard Ms. M. Learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company, praying for condonation of delay of 37 days in filing the connected MAC appeal. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Item 42.
And this case is for condonation of delay of 280 days by the filing this first appeal. Here, my lord, thing is that inadvertently, the petitioner has filed the appeal in the court of the litigants instead of filing the honorable body file. And that's why this claim was returned, the memorandum was returned.
When it was returned?
Yes.
when it was written.
Page 11, my lord. The order will find, page 11, my lord. The return by order. 17 to 2026. Page 11, the lordship is fine. There are 15. In view of the above discussion, the memorandum of April number 11 of 2025, together with all documents filed here.
After returning, after 17 to, what is the gap?
Gap is that, my lord, the whole documents was not returned. Only the order was passed. And to obtain the documents, it was ordered to return the documents, my lord.
Mr. Sharma, you have any objection?
That's lordship, the direction of the my lord, court below is to present the, my lord, memo of appeal within 15 days. The date of order is, my lord, 17 to 2026. 15 days, my lord, expired on 3/3/2026, my lord. So, my lord, from 3/3 they have filed the appeal on 11/3, my lord. So, my lord, 3/3 to 11/3, my lord, there is no explanation in the, my lord, present application.
Appeal was filed, my lord, within the time, my lord.
No.
It is, appeal is.
No, my lord.
Yet not.
The time limit framed by the, my lord, court below is within 15 days. Paragraph 15, my lord, page 11. Appeal filed, my lord, in their own statements, lordship will find in paragraph number 3, page 5 of this present application, 11/3/2026.
Appeal is there, my lord. It is not a get number. It was filed within time, my lord.
What was the when the impugn order was passed?
My lord,
My lord,
impugn order was passed, my lord, they have filed before the, my lord, in the
No,
wrong
no,
forum.
when the impugn order was passed. Fifteen,
13/6.
fine.
when you filed appeal before the wrong court? Where have you filed the appeal? Before, before additional district judge, when have you? You are objecting?
My lord, that explanation is not available, my lord, in the present application.
No, suppose they have filed the appeal within time. Before the
No,
district
that-
judges.
That's, my lord, I have,
That
regarding
was-
filing of.
The interim order was also passed in that appeal, my lord.
That was filed within how much time? Because under Article 14, the
Exclusion of
time
the
which
wrong
is
spent in the wrong
wrong
forum,
forum will excluded.
But, my lord, I am not on that, my lord.
No,
lord.
you are on that. There is a
Time limit, my
the
lord.
delay of 8 days.
My lord,
8
that has
days.
not been explained.
But suppose that 8 days is still with them. If
No, my lord.
they have filed the original appeal before wrong forum, the time is available till 90 days. Appeal.
Wrong forum is all right, my lord, but because the learned court below has given a time frame, my lord, within 15 days. They have
No, but statute also gives them time.
I have filed within time, my lord.
If, my lord, counted from the date of, my lord,
First appeal was filed within time, my lord,
That's
because
true,
of
my-
some defect and because of this condonation petition, my lord, it was not numbered.
No, Mr. Sharma, you decide whether you are conceding or if you are objecting, you file a written objection. If you are conceding, we are allowing this.
I'll file written objection.
Let him file. Heard Mr. D.C. Setia Fukan, learned counsel for the applicant. Also heard Mr. R. Sharma, learned counsel for sole respondent. This application under section 14 of the Limitation Act 1963 has been filed by the applicant for condonation of delay of 218 days in filing the connected first appeal against order. Learned counsel for the respondent, Mr. Sharma, has prayed for some time to file a written objection against the same. The prayer is allowed. Let this matter be listed. How much time will you require? 25th May. Let this matter be listed on.
Item 43.
For the first time, delay petition object, delay 712.
Advice R. Mujumdar, learned counsel for the applicant. This interlocutory application has been filed for condoning the delay, has been filed by the applicant insurance company for condonation of delay of 712 days in filing the connected MAC appeal. Let the notice be issued to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June. Do you want?
Honorable Justice says that listing will be of arbitration appeal listing will be done by this.
What is your prayer? What is your prayer?
My prayer is I want to get listed my case on day after tomorrow, let's say. Because earlier it was fixed on 16th of this March, but and that day
Okay, allowed.
Allowed.
You give the mention memo.
Obliged, let's say.
Item 44.
And Mr. S. Pego, learned counsel for the applicant. This interlocutory application has been filed for condonation of delay of 810 days in filing the connected MAC appeal. In filing the connected MFA, the issue notice to the respondents. The applicant shall take steps for issuance of notice to the respondents within 7 days from the date of this order, returnable on 10th of June.
Item 45.
Yes. What is it? 226 days. What is your name? They heard Mr. D. Day. Same order, 226 days delay, returnable on 12th June. Take steps within 7 days.
Item 46.
Speed post as well as by usual mode. Both.
Day of 67.
SK Ghosh, 66 days, 12th of June.
7.
H Burwa, delays for of 160 days. 12 June.
Nothing, this is have to amend the cost title of the conference.
And Mr. R. Goswami, learned counsel for the applicant, who praised for allowing the applicant to amend the cause title of the instant interlocutory application. The prayer is allowed.
After 2 weeks.
Let this matter be listed after 2 weeks.
Item 49.
Wait, this is your lordship, this is similar to item number 20 arising out of the same accident. We have taken steps yesterday, lordship. So that case is listed on 4-6, lordship. This may also be listed on that.
But Ms. R.D. Majumdar, learned counsel for the applicant, also heard Mr. A.
Appellant.
Bhattacharjee. Applicant, this is for
Appellant, lordship.
appeal petition.
Yes, 368.
Counsel for the appellant, also heard Mr. A. Bhattacharjee. Learned counsel for respondent number
1.
1. Office note shows that the
We have taken.
no, okay. Learned counsel for the appellant has submitted that the appellant has taken steps for issuance of notice upon remaining respondent yesterday only, hence await service report. List this matter again on 4th of June.
No, there is one I 1361, maybe taken a heard on that day.
We will take it up along with the
Item 50.
In this case, lordship, notice have been sent.
delay of
7.
Mr. R. Goswami, 57 days delay, 56 days delay. Date 12th May, 12 June. Take steps within 7 days. By speed post as well as by usual mode.
51.
Petition for combination of detail listed for the first time.
BJ Ghosh, BJ Mukherjee. Delays of 230 days. Take steps within 7 days. Returnable on 15 June.
Item 52.
In this case, there is a delay for 159 days.
159 days. Steps within 7 days. Returnable on 15 June.
Item 53.
Hey, this is your lordship. Delay is of 499 days.
499 days. R.D. Majumdar. Steps within 7 days. Returnable on 15th of June.
Item 56 for supplementaries.
Yes, lordship. Lordship, here office note dated 2/5/26, lordship. Process server reported that service is complete. So service is complete, lordship. And NCR was earlier received, so you can go for hearing.
But Mr. and Miss R.D. Majumdar, learned counsel for the appellant, on perusal of the office note dated 3/5/2026, it appears that notice issued to respondent number 2 has been duly served. Stop. It also appears that now Mr. D. Mandal appears for respondent number 1. Stop. The records of the concerned MAC case, that is MAC case number 157/2016, has been received.
As per office note dated 3/5/23.
Hence, it appears that this appeal is ready for hearing. Let this matter be listed for 30 July. 30 July, as per our roster.
30.
Item 57.
Oblige, your lordship.
May please, your lordship. Your lordship, in the last occasion, the matter was fixed for hearing. Otherwise, it is ready for hearing.
Heard Mr. S. Dr. Learned Counsel for the appellant. Also heard Mr. What is the name?
D. Burwa.
D. Burwa, Learned Counsel for the respondent slash claimant.
Right.
Claimant respondent. This matter is ready for hearing. Let this matter be listed for hearing on 30 July.
58.
May please your lordship kindly peruse the order dated T7/02/2026. The matter has already been sent to the lordship's
Yes,
attention, but since the case has been fixed today, that is why a case has been listed for others.
According to the last optional, the service अपना respondent 1 and 2 has been written answered.
Take fresh steps. Heard Mr. What is your name?
R.A. Logo.
R.A. Local Learned Counsel for the appellant. On perusal of the office note dated 4/5/2026, it appears that notice issued to respondent number 1 and 2 have returned without service. The appellant is directed to take fresh steps for service for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Item 60.
Regarding service and report my case is ready for hearing, man. That's a matter.
Ms. L. Sharma, Learned Counsel for the appellant, also Ms. J. Akhtar, Learned Counsel for respondents 1, 2, and 3. It is submitted at bar that this matter is ready for hearing. Stop. List this accordingly. List this matter appeal for hearing on 4th of August.
Item 61.
May please be neither. Principal vendor is ready regard to service and LCR. It may come in for hearing.
Mr. A.R. Agarwal, Learned Counsel for the appellant. Also Mr. R.C. Paul, Learned Counsel for respondent
Number 1.
number 1. It appears from record that the service of notice on all the respondents is complete, and the records of the concerned MAC case has also been received. Hence, this matter is ready for hearing. Accordingly, list this appeal for hearing on 4th of August.
Item 62. Item 62.
Thank you, lordship. Thank you.
What is your prayer? What is the issue? Okay, for the time being.
Waiting for completion of the case. And this week, condemnation of the lady.
No.
How much day?
9 days.
39. 1339 days.
500.
You will be opposing.
My lord, yes, my lord. One, two.
The notice to Ms. Sharma, you are appearing for?
Respondent one, my lord, for the New India Insurance Company, my lord.
Heard Mr. S. Sema Lanet. What is your name? Write your name. Learned counsel for the applicant. Also heard Mr. Miss L. Sharma, learned counsel for respondent number 1. On perusal of office note dated 2/5/2026, it appears that notice issued to respondent number 2 has returned without service, whereas the service report in respect of respondent number 3 is awaited. The petitioner, the applicant is therefore directed to take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June. Registry is directed to place the postal track consignment report of notice issued to respondent number 3 by speed post within before this court on the next date fixed, list accordingly.
Item 64.
Thank you, sir. So this I has been filed seeking leave to withdraw the 50% deposited by the insurance. She came to know, my lord, that 50% means 1,88,800 deposited in April 2022. So, my lord, she is in financial distress.
Yes, Mr. Goswami. you may-
I have not deposited, the other insurance company has deposited.
My lord, I am appearing for.
She is a very
You have any objection?
No, my lord.
Heard Mr. B. Barua, learned counsel for the. This is IA 3970. Learned counsel for the applicant. Also heard Ms. L. Sharma, learned counsel for respondent number.
Respondent number-
Which insurance?
We are for affiliate, my lord. United India Insurance, my lord.
We sold the. Will deposit.
We have filed, my lord, a bill, my lord.
Appearing for United India Insurance Company Limited / affiliate. Also heard Mr. R. Goswami,
Person number 6.
appearing for respondent number 6, namely Cholamandalam MS General Insurance Company Limited. This interlocutory application has been filed by the claimant / respondent number 1 in connection with MEC appeal number 158/2022, praying for allowing the claimant applicant to withdraw 50% of the awarded amount which has been deposited by the respondent, namely, which has been deposited by the appellant, namely United India Insurance Company Limited, in terms of, in pursuant to the directions of this court. When have you deposited?
Cannot see, my lord. Cannot face time. On 27/4/2023.
last.
Learned counsel for the applicant submits that the appellant has deposited the said amount on 27/4, said amount within bracket rupees 1,88,842 on 27/4/2022 in pursuant to the directions of this court passed in IA Civil number 901/2022 on 25/3/2022. Stop. Learned counsel for the appellant insurance company has not objected to the prayer. Hence, this interlocutory application is allowed. The registry shall disburse the 50% of the awarded amount deposited before it by the appellant insurance company, namely United India Insurance Company Limited, in pursuant to the directions of this court in IA Civil number 901/2022 to the present applicant/claimant, namely Miss Sonia Rajak, after proper verification. This interlocutory application is accordingly disposed of. What will happen in main case?
In case, my lord, service on respondent number 3 and 4 is not complete, my lord. We have to take again, my lord, process step through dusty mode, my lord.
Miss L. Sharma, learned counsel for the appellant. Also heard Mr. B. Borwa, learned counsel for respondent claimant, as well as Mr. R. Goswami appearing for respondent number 5. Respondent number 6. It appears from office note that notice issued to respondent number 2 and 3.
3 and 4, my lord.
3 and 4. 2 and 3. Who is appearing for 2?
Receive back 2 and 3, my lord. Yes, my
2
lord.
and 3. Will not be served. Hence, the appellant prays for allowing prays for taking fresh steps for service of notice on the aforesaid respondents. The prayer is allowed. The appellant is directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Item 65.
Lordship, the service is completed as per the office note dated 4/5/2026. This is an application of condemnation of delay of 16 days.
Heard, Miss, what is your name? S. Patwari, learned counsel for the applicant. Also heard Mr. P. J. Burman, learned counsel for respondent number 1. You are appearing for respondent number? Insurance.
I mean, respondent number 3.
Respondent number 3, insurance company. On perusal of the office note dated 4/5/2026, it appears that the notice issued to respondent number 2 and 1 have been duly served. Stop. You are objecting?
No, Lord.
Mr. Burman, you are also appearing. Talukdar. You are objecting?
No, Lord, I'm not objecting. 60 days, Lord.
No.
16 days, that's why.
This interlocutory application has been filed by the applicant praying for condonation of delay of 16 days in filing the connected appeal wherein the appellant has impugned the judgment and order dated 15/9/2025 passed by the Motor Accident Claims Tribunal in MSC case number 235/2017. The applicant has stated the grounds for delay in paragraph number
3 and 4.
3 and 4 of the instant interlocutory application. Learned counsel for the respondent number 3 has not, respondent number 3, considering the grounds stated in the interlocutory application, has not objected to the prayer for condonation of delay. Stop. After considering the grounds stated in paragraph number 3 and 4 of the instant interlocutory application, this court is of considered opinion that the said grounds are sufficient, may be considered as sufficient reason which prevented the applicant from preferring the connected appeal within the prescribed period of limitation. Accordingly, the delay of 16 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry shall register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it. List accordingly.
Whenever the appeal is listed, my name may be shown, Lordship, and a copy may be served.
Name of Mr. P.J. Burman may be reflected in the cause list as engaged counsel for respondent number 3. The applicant is also directed to furnish copy of memo of appeal along with annexure to the learned counsel for respondent number 3.
No, bless Lordship.
Item 66.
Please vote. What about the last order were taken steps from the respondents? Lordship at Business Office was dated 4/5/26.
Yes.
This stage only wait for the service.
Okay. Heard Mr. R. Sharma, S. Sharma, learned counsel for the applicant. The office note dated 4/5/2026 shows that the service report in respect of notices issued to the respondent is awaited. Stop. The registry is directed to place the postal track consignment report of notices sent to the respondents by speed post before this court on the next date fixed. Let this matter be listed again on 18th of May.
Main reason. Although I filed this application, whereas my pen would not object. The Kingston ex parte administrative injunction, I had come before the honorable court. My lord was passed things to pass an order inter party. Maintenance of status quo. That is there. Fixing the next day. On the next day, my colleague had some difficulties, so his colleague had made a mention of the journey. Inadvertently, he rolled over to 22nd of May, was a trial court matter 16/19. We will be forced to expose our stand in the trial court before the trial court without knowing the developments of this case. So the friend is also agreeing until the disposal of this appeal, it will be consent order. With proceedings, all proceedings before the trial court, with the status quo being made, of course.
My lords.
That's all.
Well, there was a sincere mistake on a part while mentioning. It will be very unethical for me to oppose his prayer, my learned senior's prayer. My lords, however, my lords, only prayer before your lordship would be to maintain the status quo order.
And the proceedings.
The FAO is listed on 22nd of this month.
And this appeal is listed.
22nd of May.
And trial court, the matters are fixed on 19th of May.
And by order dated
What she finds it, the last, 7th of April, 27, page 27.
No, you are the appellant. The status quo was granted, interim order was granted.
Maintaining the pitch. While the proceedings be said, continuance of proceedings be said. Without disturbing each other on that score. Now, since the matter is traveled to 22nd of May, when 19th is the date there, so we will be compelled to find the WS without the developments hearing being known, because this will have a bearing on that.
But this is against only an injunction.
Absolutely, nothing more. But since in the written statement and written objection to file there, we will be taking certain steps. He also knows, but I'm not opening it right now. Without this, just a consent.
This heard Mr. S. Panik, learned senior counsel assisted by Miss Fiza Begum, learned counsel for the applicant. Also heard Mr.
N Patiri,
N. Patiri, learned counsel for the
opposite party number 1.
opposite party number 1. Who is appearing for 2?
2 and 3 are pro forma parties, my lord.
They're his people, someone will appeal.
They have received the notice. None appears today, my lord.
Then notice have to go to. Okay. This application under section 151 of the Code of Civil Procedure has been filed by the applicants in connection with
Page 9, the bill.
in connection with FO number 22/2026. Page number
9, the bill.
learned senior counsel for the applicant submits that in the connected FAO on by order dated 24/3/2026. This court directed both the parties to maintain status quo in respect of the suit property till next returnable date.
That order was passed in the interlocutory application. That is page 17. ISCB 932 of 2026.
Yes. What was the line? No, stop. From the bit. In the connected FAO in an interlocutory application bearing number, IA number
ISCB 932 of 2026. Page 17.
2026 by order dated so and so. The last word is till next returnable date, that is till 7th of April 2026. Thereafter, on 7th of April, the interim order of status quo was extended till next date. He further submits that next date of the connected FAO is fixed on 22nd of May 2026. However, he submits that before the trial court, the title suit number 68/2026 is fixed on 19th of May 2026, along with the connected miss cases. And therefore, he submits that since the orders passed in this appeal may have bearing in the pending title suit till the disposal of the connected FAO, the proceedings of title suit number 68/2026 as well as connected miss cases before the trial court may be stayed. This is your prayer. The
It is subject to the maintaining of the status quo over the suit process.
so the prayer is Mr. N. Patiri, learned counsel for the respondent, has not opposed the prayer subject to the maintenance of status quo in respect of the suit properties by both the parties. Stop. Since the respondent number 1 has agreed to the prayer made by senior counsel for the applicant, same is allowed. But we have to issue notice to.
Since plaintiff is there and they are performing the suit. Plaintiff is agreed and they are performing his suit.
Okay.
Otherwise, they don't have the right to object.
Stop. क्या लिखा? Same is allowed. Since the respondent number 1 is the plaintiff before the trial court, whereas respondent number 2 and 3 are only the pro forma defendant in the said suit. Notice to said opposite parties in this interlocutory application is waived, and this interlocutory application is disposed of.
I thought maybe please to indicate the mistake is. That's at page 10. Title suit 68 of 2026 along with mistake is 55.
Yes.
10.
Title suit 68 of page number
9 and 10.
title suit 68 of 2026 ऊपर रहेगा ये, along with Ms. J case number 85/2026 as well as Ms. J case number 102/2026 pending before the Court of Learned Civil Judge Senior Division, Kamrup Amingao, shall remain stayed.
And the status quo of the parties property is maintained by the parties.
Such shall remain stayed during the pendency of the connected FAO 2026 before this court. Both the parties shall maintain status quo in respect of the suit property as was directed earlier till the disposal of the connected FAO. This interlocutory application is accordingly disposed of.
Deeply.
Standing item 62.
Much delay? You will file.
Yes, I have filed the objection in appeal, already filed.
Okay.
Passing of the judgment,
Good. এই মাইক্রোফোন তো কাম নকৰে নেকি? You hit কৰি চাওকচোন মাইক্রোফোন. Test it. It is not working, na? Then you have to be louder.
What happened? 7/10/2016,
2710 to yes.
passing judgment issues. That the payment has been brought, the offending vehicle was not involved in the accident. He assist himself driving the vehicle and caused the accident.
Okay.
Thereafter, the insurance filed review application on 2017.
Yes.
Review application was rejected on 2/11/2020.
2024.
Yes.
Yes.
We filed the of 28/2020.
28,
2000.
25.
They occurred, the review application was pending.
No, that time you will get how much is the
43 days.
when you came to know that the fraud was committed?
We came 7/2017. And we filed the review application on 2/3/2017.
Yes. Now what is the submission?
They occurred with the review application pending. And not filed the appeal. And after the rejection of the review application, we have filed this appeal. The delay is, the occurred is sufficient reason has been for filing the appeal. On the date of the order of the review application, there is no delay in the appeal was filed within time limit.
No, still there is a delay. Review order was passed on 2/11/2024. So the limitation is still 2. When 90 days gets over. When it gets over. Yes, where from 2/4/2024 when 90 days gets 2/11. So 2/2/2025 90 days is over by 2nd of February.
Yes.
Still there is some delay. Yes, yes, Mr. Arula.
Latif,
Sometime the order. So the certificate was applied on 8/11/2024 and date on which the copy was ready for the 29/11.
How much time you get? 21 days. Yes.
Latif, Lordship, even that is so far as the delay is concerned, Lordship, initial review application is also in on delay. Lordship, the judgment was passed on 27/10 of 26.
Yes.
27/10 of 16. Lordship, but the review, Lordship, they have filed a review application.
2/3/2017.
2/3/2017. Lordship.
Yes.
After,
No, but that was for the tribunal to see.
yes, Lordship. Accordingly, that has been disposed of. Yes, that has been dismissed. The review application is being
Why?
dismissed.
On what ground review application has been dismissed?
On
Delay,
merit, of course.
on the ground of delay or on merit?
On merit, Lordship. On merit, that has been dismissed. And so far as the subsequent, after disposal of the review application is concerned, although they have shown some causes for condoning the delay, but to my this opinion, that is not sufficient, Lordship, because they took more than 1 month for this preparation of the appeal, Lordship, by their lawyer, and to get their opinion upon the same, because they knows everything, Lordship. Since 2016, they knows about the every facts, Lordship. Even after disposal of the review application, then also they were not diligent in filing the present appeal, Lordship. Yes, Lordship. In para, Lordship, in para 11 of our objection, Lordship, we have categorically objected in para 11 and 12, we have categorically objected regarding their grounds shown by them for condoning the delay, Lordship. In view of the above position, I humbly submit that their delay is not liable to be condoned. That ground also they have shown that is not a sufficient ground for condoning.
In para 8.
In,
Para 8. No, in objection.
In objection, Lordship, para 8. 8 and, sorry, Lordship, para 11. More specifically, para 11. Lordship.
Heard Mrs. Roy, learned counsel for the applicant. Also heard Mr. D. Ullah, learned counsel for the respondents, claimants. This application under Section 5 of the Limitation Act 1963 has been preferred by the applicant, that is National Insurance Company Limited, praying for condonation of delay of 3,043 days in preferring the connected MAC appeal, wherein the applicant insurance company has impugned the judgment and award dated 27/10/2016, passed in MAC case number 1796/2015 by the Motor Accident Claims Tribunal number 2, Kamrup Metro. Whereby the present applicant insurance company was directed to pay a compensation amount of rupees. How much?
30 lakhs. 30 lakhs, 5,200.
30 lakhs, 5,200, along with an interest at the rate of
5%. No, 6%.
6% per
Per
annum.
annum.
Learned counsel for the applicant has submitted that the judgment, that the impugned judgment was delivered by the Motor Accident Claims Tribunal on 27/10/2016. Stop. However, after the delivery of the judgment, when you came to know, where is
7/2007.
came to know that the claimants have indulged in fraud in seeking compensation in the aforesaid MSC case, and accordingly, in fraud seeking, it is submitted that the said knowledge regarding commission of fraud it is submitted that the fact of commission of fraud by the respondent claimant came to the notice of the applicant insurance company on 7/2/2024, 2017, and accordingly on 2/3/2017, the applicant insurance company preferred a review application before the Motor Accident Claims Tribunal. The said review application was registered as Miss Case number 9/2017. Stop. Learned counsel for the applicant further submits that the Motor Accident Claims Tribunal, by its order dated 2/11/2024, had dismissed the review application. Thereafter, she submits that on 8/11/2024, the applicant had applied for getting certified of copy of the order passed in review petition, and the said certified copy was furnished to the applicant on 29/11/2024. That is after 21 days of the applying for the certified copy. Thereafter, on 28/2/2025, the appeal has been filed by the applicant insurance company. She submits that in the process, the delay of 3,043 days have occurred. She submits that the delay has been caused in preferring the connected appeal due to the pendency of the review application before the Motor Accident Claims Tribunal from 2/3/2017 to 2/11/2024. Hence, he submits that as the applicant were unable to approach this court. Applicant had referred a review petition against the impugned judgment and award. They could not file the appeal, and said period may be deducted from the period of delay computed in filing the connected appeal. She submits that the reason shown by the applicant is a sufficient reason within the meaning of the phrase as used in Section 5 of the Limitation Act. On the other hand, Mr. Darakulla, learned counsel for the respondents, has vehemently opposed the prayer for condonation of delay of 3,043 days.
Okay. So far as here, respondent number 3 and 4 has already expired. Okay. I am for 1 and 2. Order is there? Yes, but I am. Look.
Yes, on a prayer made by the appellant. Kalika last. Repeat. (3043 days). He submits that the delay or huge delay of 3,043 days has not been properly explained by the applicants, and no sufficient reasons have been shown by the applicants for causing delay in preferring the connected appeal. Where is your written objection? Or how much period the review was pending? Compute that period. How many days? How many days? Calculate, use your mobile phone and calculate. You have a copy of written objection?
Yes, yes.
Please pass it on. he submits that even after getting approval from competent authority of the applicant insurance company, the counsel for the applicant took undue time for preparation filing of the appeal and said delay has not been properly explained by the applicant in the condonation of delay application. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on records. Stop. Though apparently it appears that the delay occurred in this case is a huge delay of 3043 days. However, this court cannot overlook the fact that most of the time from the aforesaid 304 days, there was a review application pending before the Motor Accident Claims Tribunal from 2/3/2017 to 2/11/2024, which come approximately at 2,799 days. It also appears that the period of 21 days which was required, which was consumed for getting certified copy of the order passed in review application has also been deducted from the total period of delay, as the applicant had no control over grant of certified copy. Further, some time was also consumed in getting the approval from the competent authorities of the insurance company to get clearance for filing an appeal. Stop. It is no longer it is a settled proposition of law that court are to take justice-oriented approach while dealing with an application for condonation of delay. And since the allegation of fraud has been leveled against the complainant, this court is inclined to take a liberal approach in this matter and accordingly condone the delay which has occurred in preferring the connected make appeal by the applicant insurance company. This interlocutory application is accordingly allowed, and the registry is directed to register the connected MAC appeal and list the same for admission after 2 weeks on a date to be fixed by it.
Yes. For hearing, item 68.
You have 45 minutes. Though we have more time.
45 minutes should be sufficient.
Yes, for both. You have already completed. Completed. এটা printed here ছিলে. Yes, Mr. Paul.
May please, Your Lordship. The facts and circumstances of the case. First of all, thing, my lord, my friend has filed this memo of appeal and annexed the documents, various documents, but he has not failed to annex the chief of PW1, PW2, and PW3 and DW1, as well as the cross examination.
That is not a ground.
No, not a ground. I'm not going to
Because-
say. my lord.
Because we have
Yes.
requisitioned the
Yes.
records.
Yes.
So even if we don't annex,
That is not necessary. Although, because he has submitted that part, it still indicates that some, when I go through this cross-examination, kindly see this cross-examination, and PW1, and as well as the chief.
what is your submission?
Well, I'm coming. It is the PW1 chief stated that 1/6/2014 at about 4 p.m. I was coming along with my husband from Nokat, Dibrugarh by vehicle bearing number so Ford, and which was driven by my husband Jagat Sonowal, and while reached near Dikhang Bridge on 37 National Highway on one vehicle registration number Indica hit our vehicle from backside, as a result of which the said for fell down in a ditch, and my husband Jagat Sonowal died on the spot. I suffered bodily injury. This is the important due to ration negligence of the Indica car. And what is the cross? I have flag mark. But two paragraphs is important.
Yes.
দুর্ঘটনার সময়ত আমি গাড়ী আমি চলাই আছে আৰু উক্ত গাড়ীত মই আছিলো।
Yes.
আমি প্ৰায় 80 কিলোমিটাৰ বেগত গাড়ী চলাইছিল। 80 কিলোমিটাৰ, 80 kilometers.
So what? It was a national highway.
I'm coming, my lord, coming. See this kind, my lord, there is a judgment also there. The vehicle was flying with a speed of 80 kilometers. It is an admitted fact because she was there. I do not know she was there or not. Because she was there or not. That is very important. I think the deceased himself riding, nobody is there. This is my
Your
son.
thinking will not do.
No, no,
You show the
Yes,
on what
coming,
basis you are saying.
She got injury, but she has not submitted not a single injury report also, along with this husband case. She may not file or maybe died, may not file the case for compensation. It is up to that. The thing is that she has admitted in her chief
that I sustained injuries also. No, nothing. That is called presumption. I'm just presuming. That is the law, presumption, as assumption. 80 kilometers speed.
Yes.
আৰু আৰু দুৰ্ঘটনাৰ গাড়ী যিটো আছে স্পীড কিমান আছিল ক'ব নোৱাৰো তাৰমানে that means it indicates that the offending vehicle, that is a indica vehicle, she failed to say the kilometer কিমান আছে. Supposing in this regard, if I say, suppose that vehicle, that is the TP vehicle, third party vehicle is flying 80 kilometers, that vehicle also coming behind also 80 kilometers. But she cannot say. It itself indicates that our vehicle was not involved. Kindly.
How?
I'm saying. This is called implantation case. I'm coming one after another. So for my studies, as far as my knowledge goes, that is just I'm saying, sir, my lord. No, it is an implanted case. None of our cases, because I'm attending the court, trial court every day. I found a lot of things. Now question is that, now I'm coming, the seized, the vehicle, their vehicle on that, when, as per their seizure list, as per the seizure list of that FIGO vehicle. Kindly see this page number, memo papers. For FIGO, that is my lord, translated copy. His page is 40 and my lord
40.
40, my lord, 40. This is important, my lord.
Yes.
Top, my lord, kindly see it. REF demo, police station, requisition date 13/6/2014. It may be compared with the original 42 page, that is 13/6 at the top, requisition 13/6/14. At the same time, if we compare our vehicle, when it was seized, this is no, sorry. This is MVI report. MVI report is 13/6/2014, both the vehicle. Now come to the seizure list. Come to the seizure list. When the vehicle was seized, seizure list, kindly, page 34. Yes. Seizure list, page 34. FIGO vehicle was seized on by the police 5/6/2014. Kindly see 34 is a translated copy, type copy.
Yes.
And whereas
Where is the date of seizure?
date is, my lord, below, page 34 below, Kushal Kachari, eligible, there is a name, last right hand below,
Okay.
type copy, my lord. Even then, my lord, there is that also, 5/6 in the signature also there, in the handwriting page. And these are list of indica. And page 38, it was seized 13/6/14. This is my first point. 5/6/14, accident took place.
Now, what you want to say?
Lot of things, my lord. 1/6/2014, accident took place. Their vehicle was seized on 5/6/14. My vehicle, that is offending vehicle as alleged by them, is 13/6/14. And on that day, the MBI was done. The question is that, well, a very simple question. It is there in the spot, the place of occurrence. Why my vehicle is after 7 days, 8 days? Why my vehicle is after 8 days?
No, what you want to say?
That is the thing. That is the thing.
No, unless you say, how will I understand?
What
is your submission?
Come to the conclusion. That is why I have some submission for my case.
No, what you want to indicate by the delayed
Yes,
seizure of your,
1/6/2014 accident took place.
you must have absconded with your vehicle.
There is a nothing, there is a no pleading, no anything, nowhere. I have gone through and
Then what you want to say?
I want to say, that is why my DW says, apprehend or presume that my vehicle, that is the offending vehicle, was not involved. There is a damage. There is a damage shown in the MBI report. There may be a initial damage. It is reported by the MBI office. Damage may be there any vehicle. Everybody is keep fit. Is not applicable to everywhere. Now question that, I'm saying, my lord, it is my humble submission before your lordship, that my vehicle was seized on 13, their vehicle was seized on 5th of June, after 4 days. I'm trying to submit. What is the difference? What is the irregularity? I have got some judgment also today. I'll give in the meantime. It should be, if I involve in the accident, my vehicle should be there. If I involve in the accident, my vehicle, the police has reported that I flee away after the accident. Hit and run. It will be hit and run. Now, what is the environment hit and run? What is the MBI report says hit and run? Then after that, police has informed the office of MBI for reporting the MBI report. Nothing. Even then, police document also. I have gone through each and every aspect of the matter, every line. Why delayed? Accident took place. Why? We also generally lodge an FIR. We must mention why delayed. Why delayed? Why 5 days delay or 10 days delay, 2 months delayed? Should be mentioned. Because of this reason, we did not lodge the FIR immediately after the incident. This is important, my lord. I don't know. So far, my understanding.
No, whether you took this plea before the tribunal that
is our DW.
that your vehicle was not involved.
No, we presume that. He laughed, laughing. Presume that. I can presume. Because he has made the party to me. Because in this regard, my lord, even then PW1, cross-examination, even then chief, he said, this claimant said that it was coming. My dash behind our vehicle. Because it was flying 80 kilometers per hour. That means my vehicle also coming behind of that vehicle 80 kilometers per hour. Now question comes, PW2, eyewitness. This is my first argument. There is no whisper. There is not a single word. Why? After 7 days, 8 days, their vehicle was seized 5/6/2014. Our vehicle was seized 13/6/2014 on the same day.
No, that was a seizure made in respect of a criminal case.
This is very important. A criminal case, this is a quasi-civil case. But things is that relevancy, most of the cases there is implantation. Most of the cases I have seen, because I'm defending most of cases from behalf of the company, implantation case, because we failed to prove it. Because police has already submitted the report. Now, I let come to the now let's come to the affair. FR is, my lord,
12/6/14.
12/6/14. Why delayed? We don't know.
Husband died.
Don't say why.
Yes.
During my
But
please sit down.
you have to, Mr. Paul,
Well, I'm not arguing.
Yeah,
I'm not arguing, my lord.
yeah.
I adjourn the matter because I was silent when he was my elder brother, colleague.
Mr.
Whatever it may be.
Bhumik, please sit. Take your seat.
Senior.
You have to.
Otherwise, are disturbing me.
No,
I
Mr.
have
Paul,
some
let me
concentration.
tell you one thing, that you can choose your speed,
Yes,
but you have to complete by 4.
I try my level best. I'm trying my level best. I'm giving the assurance this will be
Yes.
most. That is, I have to bring, otherwise I have no argument.
No argument.
I will not say anything because my client has engaged me to argue the matter. Second thing is that 12/6. If it is a 12/6, exhibit 4 is the affair. Is there any averment?
Yes, there is.
Averment due to death of my husband. Okay, then lost the affair. Let me to say now, this honorable court is looking this. There is a averment. There is a delay of 12 days. Anyway, a question comes: is there is a now come PW2 eyewitness? Very important. Eyewitness says what he said. In chief PW2, in chief Parat 1, that on 1/6/2014 at about 4 p.m. I was coming along with my friend from my home, Dibrugarh, by vehicle, by handwriting, vehicle number so and so, which vehicle not mentioned, possibly figure. And while reach near Dishang Bridge on 37 National Highway, one vehicle bearing number Tata Indica hit the vehicle front, which was coming ahead of us. Ahead means both of us going, both the vehicle going, that is the deceased vehicle is ahead, then the offending vehicle. Then he was behind them. How much he was behind them? Yeah, ahead. Us means ahead. From backside. He has seen. He said that from backside, as a result, it is happened, fall down and ditch, and later on died. This is the main. Now come to the my lord cross-examination. PW2. Well, kindly see the, I have flag mark, my lord. I mark it.
Yes.
Particular, my lord. ঘটনাৰ সময়ত মই এখন বাইক চলাই গৈ আছিলো। ঘটনাৰ সময় 50 feet অন্তৰৰ পৰা দেখিছিলো। 50 feet, he has seen 50 feet. He has seen from 50 feet. From whose side not mentioned? From whose side not mentioned? It itself indicates that vehicle, deceased vehicle was going ahead. Then the offending vehicle, then he was coming. Motorcycle was coming. মই মোৰ বাইকৰ 50 feet অন্তৰৰ পৰা চাইছিলো ঘটনাৰ সময়তে গাড়ী দুইখন প্ৰায় 50 কিলোমিটাৰ স্পীড আছিলে হি ৱাজ অলৰেডি মেজাৰ্ড 50 kilometer speed 80 kilometer speed if I presume that the claimant she was herself was flying traveling her husband vehicle and possibly she has seen the reading 80 kilometers 50 kilometers vast difference 30 kilometers this is important there is no mention then he denied that I have not seen the scene. The question come, my lord. Question come whether he has informed the police, whether he has stated in the whether he has informed the police whether the vehicle, the offending vehicle was there or not. He has stated in something else in the chief. So far I understood. My lord, paragraph 2, that we stop paragraph 2, chief PW2 near the place of accident and try to rush the injured lady to nearby hospital. In the meantime, the police personnel come to the place of accident and proceeded accordingly. The said accident was caused due to rationale. This must. Who informed that vehicle? If it is there, suppose my vehicle is there, the police has come thereafter. Immediately police has come, police has requisited my vehicle. Why after 8 days? Why after 8 days? Well, this is the circumstantial evidence. That is happening in the amicity case. This is happening. I have a lot of cases, this type of cases. Why not seized? Suppose their vehicle seized on 5th of June. Accident took place 1st of June. My vehicle was seized on 13th of June. See the corroboration. Even the eyewitness. If we depend on the eyewitness says that accident took place. Eyewitness says only they said accident took place because of his his fault of one particular vehicle.
So your submission is as it was seized belatedly.
Yes.
Therefore, it is not involved.
Was not there.
Okay.
So far I understood.
Okay, and why PW2 should be disbelieved?
Because if the police has come thereafter, because paragraph 2 is clear, very much clear, police has come. So why not police has seized on that day, particular date? Because 1/6/2014.
Okay, that point is taken.
It itself indicates this is a circumstantial evidence that my involvement of the Tata Indica. I try to submit to her lordship. Involvement of the Tata Indica. It's nothing. It is absent, totally absent. Then it is seized on 13/6/2014. Even then on that particular date, both the vehicle was MVI. Then after 13 days. So suppose he was there, police has come immediately after the accident. Then why not seize both the vehicles?
You come to next point. This point I have understood your argument.
That means I come to make lordship is a contributed negligence. I said my vehicle was not involved in the vehicle in the accident. I said because DW said. Even then, DW is there is a two part. One part is a damage of my vehicle. kindly see figure, the body, the structure of the figure and structure of the indica, almost same, equal to. Almost equal to. And it is running 80 kilometer speed, admitted fact. And he said, the PW2 said 50 kilometer speed. Okay. Then if it is, I hit behind the back, what will happen? The figure's vehicle, this deceased vehicle, what will happen? Backside will be totally damaged. First, then it will be, if it is
Now,
turned.
suppose you have hit on the right hand side, how backside will be damaged?
That is, see this, I am coming in two ways. Suppose, first thing is the implanted vehicle, second thing, suppose I hit, because it was an 80 kilometer speed, 80 kilometer speed, he could not control. Then I was coming behind, that is the judgment is there, I have in my hand, because it's a wrongly charged. Because he was, speed is going, the figure vehicle was flying at the speed of 80 kilometers. Heavy speed, but I know this road because my house is big boy. I'm always coming this road. And if it is going, because it is on the breeze, it is happened on the breeze, and it is also stated that a thrust or hit a one tree, then ditch, fell down. That figure was fell down, and that after falling, then husband died, but she sustained injuries. What type of injuries? Nothing. Not a single document. I've gone through this record of the injuries that I also sustained injuries. This is the treatment. See this minor quality of the case. This is my treatment. Only the averment made in the affidavit is not sufficient. You have to prove by giving some document. But this is a case. The deceased himself was riding the vehicle and he lost control. Himself dashed the tree and fell down and died. Then these are all concocted and manufactured evidence. Even then, this claimant during the trial did not summon to the police. Because police has seized. When seized, it is reflected as per document. Did not summon the police to justify this particular documents.
Okay.
Now, my lord, come to the evidence of DW1. And as chief, my lord, he has not annexed in the records. I cannot say the page. Chief.
No, if you want, you can go through it.
No, I've gone through. I have this particular.
What you want to point out?
I have
Make your
point out
submissions.
that the damage column. MVI report is very important. Damage column. We have mentioned, may I kindly go through this DW1, chief.
Yes. Yes,
Para number 2, that on investigation, I have collected the seizure list of 2 vehicles bearing number so figure and the indica along with the MBI report. On such investigation, it has come to light that the vehicle bearing figure was seized on 5/6/14 and the accident occurred on 1/6/14, but the Tata Indica seized on 13/6/14 as per record. To seizure list, we annex B and C are the exhibits. Now, paragraph 3, I have further deposed that MVI report of car said got MVI report of car. Car means possibly Indica card. Said got damage from the front side, such as front rect seat glass, bonnet. It is clear, my lord. It is apparent in the MVI report. Exhibit 6A and B itself. And I also given the exhibit. My kindly see these exhibits.
No, what point you want to make? You have to make
My
your
kindly see this.
submissions.
We have it is evidence. We have reverted their claim, reverted the accident, specifically accident. We have reverted. First reverted that what is the damage? If I dash something, this vehicle is going very high speed. I am also going high speed. The PW1 nowhere stated that it is coming in high speed because she herself stated 80 kilometers her vehicle. My vehicle, if I hit, I am also going in 80 kilometers speed, and I dashed behind that vehicle. Then question come whether ration negligent. Ration negligence might be their vehicle. That is why, because high speed, she could not say.
I'm not getting your point.
The Figo vehicle was flying or traveling in 80 kilometers.
Yes.
Now my vehicle, how much speed she could not say, but the PW2,
It has to be 80 or more than 80.
more than
It may be in 100.
Otherwise, I'll cross that vehicle.
No, but if you hit,
If I more than 80, I'll cross him because otherwise, if it is 80, I'll be parallelly go or behind.
no, but the evidence is you have not gone on your own lane. You have hit the Figo from right hand side.
That is the thing.
That is the evidence on record.
Right, and that is why
And how you rebut that evidence?
that is the thing, my lord. That is why I'm coming and rebutting that evidence that the MBI report says what is the damage part? Damage part of both the vehicle. Damage part of both the vehicle. If I hit,
Yes, I have gone through what you want to say.
there is a no damage part. If I hit, not from I'm not hit from my backside. I hit from my car, that is Indica car, from front side to the backside of the Figo car. What will happen? Backside of the Figo vehicle and front side of the Indica vehicle will be totally damaged. More or less will be damaged. On see this damage column, it itself indicates.
So your submission is there was no collision.
There is a collision.
No, your first submission is that your vehicle was not there. Then you are saying that there was a collision. You have to make one submission.
There is a collision. If my vehicle is there, first presumption is that my vehicle is not there. Secondly, if my vehicle is there, that you also ration negligent.
Okay.
Driving.
Okay.
That
It
this
was
is
because
also
of
driving.
Figo's ration negligence.
Also,
You
because
hit the.
he coming back because he could not control. In this regard, I can give one judgment also. This honorable.
Okay.
This is-
Okay. Proceed with your argument because you are where you started 20 minutes earlier. You have not proceeded
You know,
further.
little times because
You will not get time.
No, this is my argument, my lord. This is the point of argument. The
Okay.
thing is that if I say yes, my vehicle was there involved, then involvement and on the basis of the involvement report. If I say that you also going parallelly going, then when I touch it, because his reaction, because that vehicle, Figo vehicle, was going adhered to me, my vehicle, and one person is going by motorcycle also 80 kilometers or 50 kilometers, whatever it may be, also behind both the vehicles. He has seen. This is the thing. So that is the thing. There is a contribution. If I say on the letter, if I forget it, the first my argument that the contribution of negligent. The contribution is that you also going 80 kilometers, although landed tribunal did not mention entire things. It has to be mentioned that what is the evidence. The evidence part never mentioned. It directly come to the that there is a contribution due to contributory negligence. not mentioned. When you go through the record, there is something else different. If you go parallelly, you also going parallelly, you are taken the, in a Dogar case says, why not wife caution this husband, somebody is coming ration negligently behind the bus, you take care of. I'm giving the 2006 judgment. There is a clean, one prudent man should care of. Prudent man should care of. That is what Supreme Court says. It is our case of Assam. That it is ultimately apportioned 50-50. I'm giving my that judgment also. Dogar case.
Okay, you proceed.
Now question come. Suppose now question is negligent. It is the findings of the learned tribunal is a negligent, that is contributed negligence. Then if I say the contributed negligence, then why not caution to her husband because another vehicle is coming behind.
Okay, I got your point.
Then
That wife failed to caution, therefore there was a contributing negligence.
contributed
Okay.
negligence.
Then next proceed to next point.
And my lord, there is three things. The first thing, it not involved in the accident. If it is involved, there is a contributory negligence because this, as per evidence, evidence on record says that it is also going high speed. If I go high speed,
This submission you have made for so
on the basis
repeatedly.
of record,
Repetition is not required.
on the basis of record. So this is my argument. I'll finish it.
Okay, then
So the judgment delivered by the learned tribal court, rightly did. There is no mistake. I'm giving the two judgment.
which judgment you are relying?
This is our High Court judgment. This is a motorcycle going behind us because of ration negligent driving of the truck which was going ahead.
What is the citation?
Which para you are relying? On what point you are relying?
Point of relying, my lord, the ration negligent. Our vehicle is not negligent. Their vehicle was negligent.
No, how this judgment helps you?
My vehicle says that in this particular case, I was there because it is judgment goes to the against the Reliance. They filed an appeal and it is dismissed that the charge sheeted, the truck was driver, against the driver of the truck was charge sheeted. And the motorcycle going behind the truck and dashed the truck because there's a negligent driving of the truck. Almost similar case. And that is why their appeal is dismissed and upheld the judgment of the trial court. And some judgment also, my lord, here also quoted.
Okay, heard Mr. P. Bhumi.
Another judgment, Dugar judgment.
Yes.
Because the question, what is the necessity for another judgment, my lord, recently on Bina Devi, it is also, I am also there. The same thing.
On what point?
Point is that that Lane trial court is decided there is a two vehicle, truck and wagoner. So we say, as per the MBI report when exhibited by the one insurance company that enter judgment award is against me. Then we have filed an appeal. This honorable court has apportioned 50-50. Same type of charge.
Citations are not given to us. We cannot go through the.
My brother, you also not given to me.
Why should I give citation? I've already given citation.
I'm saying, no.
Read
Read it. MSc Appeal 91 will be 20.
Yeah,
You read it. You tell me, don't
give us the citation.
And first is, my lord, MSc Appeal C76/18. And second is, my lord, first is Reliance versus Parul Hazarika. Second is MSc Appeal 91/2020, Bina Devi versus New India and United. Both the cases, my lord, decided 50-50. And as the High Court also, this honorable court also 50-50 also, Veena Devi case. Because entire judgment was absolved against the United Insurance Company. Then thereafter, after hearing that 50-50, on the basis of the, my lord, MBI report.
Okay. Eh, Yes.
Vijay Dagar is this, my lord, 2006 3 SSC.
No, Mr. Paul, this is not the way you should assist the court. If you are relying on some judgment, you have to mention why are you relying, which point helps you.
My lord, due to contributed
Merely
negligence.
because
Contributed negligence.
there may be thousands of judgments on
contributory
contributory negligence.
Contributed
How, what I'm saying, there may be thousands of judgments in respect of contributory negligence.
Contributed negligence.
How it helps you that you have to,
On the basis of the, my lord, MBI report, the contribution, what the learned trial court has come to the finding that there is a contributed negligence. In what aspect it become contribute both the vehicles has contributed the accident.
okay.
That is the thing, my lord. This is the case only. This is the case. I'm not going to say that my quantum or any other thing. Because it is an accident. Accident I have not disputed.
Yes, Mr. Bhumik.
Well said. First is that in order to take the plea of contributory negligence.
That you have,
should be specific
the
pleading.
pleading and proof you have already submitted.
And secondly, my learned friend has said that the fact that the co-passenger, the lady, has sustained medical injuries and those medical reports have been exhibited as exhibit 9A to 9D. So that is an incorrect statement that the lady has not sustained it. The lady has indeed sustained injuries, exhibit 9A to 9B. And thirdly, the delay in lodging the FIR has been explained. Lordship will see the FIR.
Okay.
This is not my lord, vital, but it is my circumstances. Mainly is that my MVI report, seizure list, very important. These two things and my DW.
Okay.
And on the basis of contribution negligence, this is my judgment, so this honorable court judgment, this is Veena Devi cases. It is apportioned ultimately in this High Court, this honorable High Court.
Okay, heard Mr. P. Bhumik, learned counsel for the appellant. Also heard Mr. R.C. Paul, appearing for the respondent insurance company. Hearing concluded, judgment reserved.
My lord, in the meantime, may I give one written argument?
Yes, it will help me. Yeah.
I don't know, I can finish or not. 1 week's time I'll. And then that week.
Give a copy to us.
Yes, give a copy to them. Within a, or should I fix the date for giving written argument?
19. Within 19.
Okay.
19 of this month.
Uh,
If also my friend is wish to give.
Hearing concluded. However, as learned counsel for the insurance company intended to give a written argument, in gist of his written argument, gist of his argument in writing, let this case be listed again on 19th.
If my convenient this honor. Because I have a number of cases fixed for
19th of May.
May. I think
19th of May for submission of written argument. The counsel for the respondent insurance company is requested to give an advance copy of his written argument to the counsel for the appellant. And if the counsel for the appellant wishes, he may also submit his written argument. Though I have taken note, if you want, you can also submit.
Let's see what he gives.
No, this is not the thing. I'll submit on 19th because it will be
You
listed.
give an advance copy to him so that he can
No,
submit.
I will give one on the morning on 19th because it will be listed.
He intends to take me by surprise.
Because on the basis of my argument,
Oh,
he will prepare another thing.
He intends to
My
take me by
friend will
surprise.
prepare another thing. This is because lot of things in there.
you give, you sir.
But it will be listed on 19th. On the 19th, I'll submit. And on the same thing,
Your submissions I have noted down.
Required, I will give a reply, otherwise it will.
Okay.
No, it is
Nine.
not a minor claim petition. He will file a WS. It is a written argument to bring on record or to assist the court. This much.
But it is a standard practice to furnish copies of it.
That will I practice. It doesn't mean that I'll give you the 1 year's back. This is not the way. I'll give on that date. This lordship has fixed a date. On that
19th.
On 19th. I'll submit on that day. Much of this. Much of it. Sorry, my lord, taken time. 45 minutes I finish. This is some complicated case.
No,
Much.
Now, in this case, the opposite counsel for the opposite party has not filed the Wakalatnama till date. As per last order, they were supposed to file their Wakalatnama matter.
then we'll proceed ex parte.
Some
Heard Mr. P.S. Bhattacharya, learned counsel for the applicant. None has appeared for the respondent, though on last occasion, one Miss M. Kalita appeared and submitted that she would be filing her Wakalatnama in this case. Let this matter be listed again after 4 weeks on a date to be fixed by registry.